The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division First Department's virtual argument session. I am going to begin by calling the calendar, so please listen carefully. People versus Kevion Hill. For the appellant.
Yes, Your Honor. Counsel for appellant, we have 5 and 1.
And you are?
Cami Lizarraga from the Office of the Appellate Defender.
Thank you. Yes, 5 and 1. And for the respondent?
Good afternoon, Your Honor. Carl Dubel from the Manhattan District Attorney's Office for the people, and I believe we are allotted 5 minutes.
I'll let you know how much time you have. If you just state your name, that'll be fine. Thanks. So that's 5 and 1 and 5. Jones versus Feggs We Care is submitted. Justice V is submitted. Oliver Boone for the appellant.
Ted Porras, Your Honor, for the appellants.
6 and 1 for the respondent.
Good afternoon, Your Honor. Brett Galloway, McLaughlin, and Stem for respondent.
6 minutes. Scott versus Triborough Energy for the appellant.
Good afternoon, Your Honor. For the appellant, Jeff Sunshine, we have 5 and 1.
5 and 1. For the respondent.
Good afternoon, Your Honor. Adam Kucinich from Donahue Law Firm for the respondent.
5 minutes. Okay, 5 minutes. Thank you. Yeah, you sound a little far away from us, so you might want to adjust your volume when you're ready for argument.
All right, thank you, Your Honor.
Muller St. Cyr versus New York City Transit Authority.
You have Michael Marin for the appellant, Your Honor.
That's 5 and 1 for the respondent.
And Barry Montrose for defendant respondent.
Barry Montrose. That's 5 minutes. 5 and 1 and 5. Edstrom versus St. Nick's Alliance is for the appellant is submitted, and for the respondent.
Ryan Sestak for the respondents.
2 minutes. People versus Gregorio Burgos for the appellant. For the appellant in People versus Burgos. I'll come back. Antipara versus Garcia is submitted. Crown Jewels versus Underwriters for the appellant.
Good afternoon, David Benheim, Lipsius Benheim Law for the appellant.
6 and 1 for the respondent.
Dennis Wade Clark Mulcahy for the Underwriters at Lloyd's.
That's 6 minutes. Ackerman versus, you're welcome. Ackerman versus Nathan Dembin and Associates is submitted. People versus Kevin Richardson for the appellant.
Good afternoon, Your Honor. Ariel Reed of the Center for Appellate Litigation for Mr. Richardson.
3 minutes for the respondent.
Good afternoon, Jillian Lewis for the Manhattan District Attorney's Office.
That's 3 minutes. Technology Insurance versus First Mercury Insurance for the appellant.
Dan Cohane, Hurwitz and Fine.
5 and 1 for the respondent.
Kristen Gallagher of Kennedy's for the respondent.
5 minutes.
Thank you.
Wong versus 15 Monroe Realty for the appellant. Wong versus 15 Monroe Realty. Appellant.
Thank you, Your Honor. Marsha Rakes for the appellant, requests 4 and 1.
4 and 1, thank you. And for the respondent?
Lisa Gokulsing for 15 Monroe Realty.
That's 4 minutes, thank you. Trugate versus Barokian for the appellant?
Yes, for the appellant, Daniel Thomas, Your Honor.
5 and 2 for the respondent?
David Feinsilver for the respondent. I would request. I was going to request 4 and 1.
Well, you don't have a cross appeal. You can request 4. I'll give you 4.
5 minutes. 5 minutes.
You like what I gave you originally?
Yes. Yeah.
Okay. Well, we'll see if you need that much time. You don't have to use it if you don't need it.
I will.
People versus Jacob Fashikin for the appellant.
Nicole Giaglis, Center for Appellate Litigation for Mr. Fashikin.
5 and 1 for the respondent.
Luis Morales, Manhattan DA for respondent, Your Honor.
5 minutes. 320 West 115 versus All Building Construction for the appellant.
Thomas M. Mulaney from the Law Office of Thomas M. Mulaney for the appellant, Your Honor.
5 and 1 for
Thank
the
you.
respondent.
Jessica Erickson with Hannum, Farrick, Prendergast, and Merlino for respondent.
5 minutes.
Thank you.
Robotham versus Wackenfeld for the appellant.
Stephen Beisfeld for the appellant, Your Honor.
5 and 1 for the respondent.
Kevin Clinton of Lewis Joes for respondent Wackenfeld.
5 minutes.
Thank you.
Welcome. Hunlock versus New York City Transit Authority is submitted. Davis versus Richmond Capital is submitted. Strategic Funding versus Steenbach is submitted. And I'm going to recall number 8, People versus Gregorio Burgos for the appellant.
Yes, I apologize, Your Honor. I was having technical difficulties. Danielle Krumholtz with the Center for Appellate Litigation for the appellant.
4 and 1, and for the respondent.
Molly Morgan for the respondent, Your Honor.
That's 5 minutes. Counsel, please remember, as always, that we have your briefs, we have the record, and we're fully familiar with the facts of your case. So please go directly to the most important points that you wish to make. Also, as is customary, please don't speak when a justice is speaking. This is particularly important, of course, during our virtual arguments in order to hear the question that is asked. And finally, please keep your mics muted until your case is called so that we can hear the person who's speaking. Thank you for your patience and your cooperation. The first case for argument is People versus Kevion Hill.
Good afternoon, Your Honors. Cami Lizarraga from the Office of the Appellate Defender on behalf of Kevion Hill. Mr. Hill was seized by the police.
Counsel, let me just ask you, first of all, the waiver of the right to appeal, there's no question that's been conceded. And because of the suppression hearing issue, correct?
Correct, Your Honor. The appeal waiver here was invalid, and respondent in its brief does not defend the validity of that waiver, so we can go straight to the merits here.
Okay, so then let me ask you with regard to the merits, whether or not when the defendant turned around, we're talking about, we can go right to the elevator, right?
Yeah.
Right. When a defendant turned around and went back into the elevator, would you call that a pursuit by the police in the manner contemplated by cases like Bilal, or was that more of an approach or something else?
Your Honor, that was a pursuit, not an approach. And the distinction between a pursuit and an approach is the interference with the person's right to leave. The Court of Appeals has held that at level 1, which is what the court held this encounter was, a level 1 encounter, the Court of Appeals has held that the person retains the right to walk away. So while a police officer can come up and ask a question, the person can walk away, which is what Mr. Hill did here. The officer testified that he got out.
This was an elevator, wasn't it? This was an elevator. There were people on it. There was someone waiting to get on it. The gentleman, I think, before much time had passed, looked at the police officer, I think, swore under his breath and walked back. At that point, didn't the officer have the ability to sort of ask him to leave so that he could ask him some questions, sort of guide him to a different location? Why was that? Why was this? Why do you argue that what happened was more than just guiding him?
Certainly the officer had the right to ask him, sir, come over here, but he didn't do that. The officers never testified to a request to Mr. Hill to come with them. What they testified to is that when Mr. Hill turned around and went into the elevator, Officer Pimentel said, I decided to stop him. He went into the elevator and stood in the doorway and prevented the elevator from leaving. Mr. Hill literally could not go on his way at that point, and not being able to go on your way is the definition of a seizure. The officers
Counsel, this is Justice Kennedy, and I watched the video, and what the video indicates is that an officer placed the hand on the elbow and guided him off of the elevator. So what you're arguing really is contradicted by the video. The hand was placed on the elbow, guided out. To me, that seems more like an approach rather than a seizure. We don't have guns drawn or anything like that.
To the contrary, Your Honor, we have the officer's own words admitting that he grabbed hold of Mr. Hill.
Well, we know about words, but you know what? The video says everything. And the video clearly indicates a guide on the elbow and escorting off the elevator. So let me ask you this question. Are you disputing my recitation of the video, which is so clear?
Your Honor, what the video shows is Mr. Hill turning.
No, that wasn't the question. My question is, are you disputing my recitation of the video? That's a yes or no.
Your Honor, yes, I am disputing it to the extent that you contradict the officer's testimony here. The video shows the officers going in and grasping hold of Mr. Hill's elbow, holding him with one arm and then the other until they pull him out, as the officer also testified. Your Honor certainly is correct that this was not a violent encounter. It was not, but that is not required for a seizure to be affected. It's true that Mr. Hill was not dragged out of the elevator or anything like that, but the video.
Why isn't this consistent with other cases where in a level 1 you can ask the person to step aside? There were other people on the elevator. Are you suggesting they should have gotten on the elevator and ridden up and down with him, with the other people on the elevator?
Your Honor,
instead of, I think, let me put it this way. They say that they intended to arrest him then, but what happened was that he put his hand on the elbow. The video doesn't show him pulling him out of the elevator. I think your words suggest that perhaps that's what the video shows. That's not what you're suggesting the video shows, is it?
well, what the officer himself said was that he pulled Mr. Hill out of the elevator. That's on page 76 of the transcript.
I understand the words. I understand the words, but words don't always match what the video shows, and we see the video. So are you saying that he touched his elbow, as it suggests in the video, and guided him out, or that he was pulling him by his elbow?
Well, Your Honor, this was not a circumstance of guiding because there was no request here. That's how this is different from the guiding case. In the guiding case cited by respondent, the officer asked the gentleman.
So it can't be nonverbal.
Correct.
It can't be a nonverbal suggestion where you suggest with your hand and guide. That can't be.
Contextually, not in this case under these facts, where the officers never testified that they made a request that he come with them such that this could be a voluntary interaction. What they testified to was that they decided to stop him. They went into the elevator. They stopped the elevator from leaving. And Mr. Hill, in his attempt to leave, they, if you want to say, take hold of his arm, which is shown in the video that he switches from one hand to the other and then takes him out. There is never any testimony from these officers that this was a voluntary interaction. It was a physical detention.
Thank you. Counsel?
Good afternoon, Your Honors. May it please the court. Carl Dubel for the people. Just to briefly
counsel, let's begin where opposing counsel left off. Why couldn't the officers, because the officer does say, that I decided to stop him. He doesn't say, I decided to just ask him to come off. He didn't ask him to come off. He said he decided to stop him. And it doesn't appear that he says, sir, would you please come over here? It appears that he uses physical, he was physical in order to get him off. So why isn't it at that point beyond a level 1?
So to address your first question about his subjective intent to stop him, I don't think that's incredibly relevant. What his thoughts were, I think what's more important is what actually happened, and that's described, I think, best by the video.
Okay, but let me ask you this. does he just ask him, or does he use some physical means to get him off? Does he ask him a question and ask him to comply with that question? Would you please get off of the elevator so we can ask him? Or does he use physical means to get him off?
So he does not physically or verbally ask him, would you please step off the elevator? What he does do is he walks into the elevator and he points with, I believe it's his left arm, or points or gestures out of the elevator, which I think is a pretty clear nonverbal communication that he wishes to speak with him somewhere else. And then what he does as the defendant starts to freely walk out of the elevator is with his right hand is he does physically touch him. I think that's clear from the video. But as the trial court found in his very specific findings of fact that this contact was light, it was not coercive, it was not heavy-handed. And I think the video supports that conclusion of the testimony. And even if there was contact, I think that's still acceptable. There's multiple cases from this court which support the idea that an officer can make either non-threatening physical contact is from People versus Woodfall. And from another case, People v. Francois, the officer actually did physically grab the defendant's elbow as they walked away from a MetroCard machine to speak in a more, an area more susceptible to questioning and out of the way of public traffic.
What about when the officer, as he's questioning him on the side, one of the officers stands in front of the staircase? Does that suggest that he is stopped at that point and rested without the freedom to leave because the only means of egress is blocked?
A seizure did not occur at that point either, Your Honor. The Officer Pimentel, who was not the one by the staircase, he was standing in the corner of the hallway with an open hallway with defendant a couple feet away, and then I believe the other officer, Thomas, was the one who was standing over by the stairwell, which was on the other side of the hallway and even farther away from the defendant than the officer who was questioning him. And that was not the only method of egress, I believe, out of the hallway. He could have walked down the hallway. He also could have walked at the elevators. There was no testimony that the officers were standing in his way of walking back to the elevators if he chose to do so or requested. They also, when they were questioning him, these were plainclothes officers. There was only 2 of them compared to 1 of him, so that he was not significantly outnumbered. Their guns weren't drawn, and I think the most important fact is they really weren't asking threatening questions. They were asking appropriate level 1 questions, which tends to indicate that this was not a seizure, even at that point outside of the elevator.
Thank you.
Yes. If there's no further questions, we just ask that you affirm.
Thank you. Counsel, we're back to you. Ms.
Thank you, Your Honor. Just a few things. My adversary's agreement here that there was no request by the police is critical because that's what distinguishes this case from the cases cited by the court below and by respondent.
Well, he says there are no words, but he says there's a nonverbal communication by the gesture of the hand.
No, Your Honor, it's not a nonverbal communication. It's a detention. Mr. Hill tried to walk away from the police in this case. The officer said so. He came out, sees him, uses the curse word, turns around and walks away. The entire factual predicate for this encounter is his attempt
back into the elevator.
Right.
I don't know that he got out of the elevator, but he walked back. He was just on the threshold. He turned around and walked back in.
True, Your Honor, that's true. He stopped on the threshold, went back in, but that was still a retreat away from the police and an exercise of his right to walk away. And respondent does not dispute that the police prevented that from happening. It wasn't.
Well, they had a right to ask him questions. They had a right to ask him basic questions of a level 1.
Certainly, but not
which is what they asked.
But not the right to detain him from walking away in order to ask those questions.
Counsel, this is Justice Kennedy again. I have another question. Why shouldn't this court give deference to the hearing court's determination that no significant limitation was placed on the defendant's freedom?
Because, Your Honor,
that was the determination.
Because, Your Honor, the court's fact finding that the officer did not grab Mr. Hill, did not only lightly touched him, did not pull him out, were unsupported by the officer's own testimony. And in addition, Your Honor, the court did not deny the facts that show the pursuit here, that Mr. Hill was prevented from leaving, and that the officers never made a request here. So this was not a voluntary level one interaction, a non-threatening interaction where the person answers a question, but also can refuse to answer and walk away. Instead, it was a physical detention of Mr. Hill, preventing him from leaving him in the elevator and detaining him for questioning that was not voluntary, was physical, and was a seizure under well-established Court of Appeals precedent. And as a result,
Thank you, counsel.
Thank you.
Thank you. Thank you both. Next case is James Oliver versus Mary Boone, Boone Associates, and Mary Boone Gallery.
May I proceed, Your Honor?
Just give me one moment.
You can hear me.
Yes, go ahead.
Ted Poritz and Zuckerman Gore for the appellants, Your Honor. 6 minutes, got a lot of ground to cover, so I'm going to talk fast.
Okay, and I'm going to ask you a question. Do sections 3.4 and 8.3 of the 1977 partnership agreement conclusively state that a limited partner must make a capital contribution?
It says, in essence, that a limited partner only gets distributions in proportion to the capital contribution. So yes, the answer to that is yes.
Well, what about the other section 9.3, I believe it is, and the amendment? Don't these sections together just indicate a formula for how the profits are to be calculated? And it doesn't then say that one can assign, a limited partner can assign her rights or his rights?
So it says some of those things, not all. The provision that Your Honor talks about, 9.3 and Amendment 5 to the certificate, by the way, not the agreement, recites the boilerplate proposition.
Right.
Recites the boilerplate proposition that people get distributions in accordance with their capital, with their percentage interest. Every partnership agreement ever written says that. But you have to read all of the provisions together to see if they can be read consistently before we start talking about ambiguous provisions and parole evidence. And the obvious only way to read those provisions so that they all have meaning in line with Your Honor's precedents is that you get partnership distributions in accordance with your percentage interest if you have paid capital contributions, and clearly Mr. Oliver did not. Otherwise, what you have is a contract partner. Like so many lawyers in New York, you get the right to call yourself a partner, but you don't get equity. So that's what that provision says, and I think there is no ambiguity, and there certainly is no need for parole evidence because you can easily read those together, and your precedent calls on you to do that.
I'm sorry, but doesn't 9.3, since you said that it does, if you read 9.3 with 3.4 and 8.3, doesn't it then read out 9.3 if 9.3 talks about how you can, how the profits are to be allocated? Rather.
I'll argue that it would do the opposite under the other interpretation, Your Honor. There are clearly provisions that require capital contributions. And if you only look at 9.3 and you don't read them all together, then you have read out the provision that calls for capital contributions. And clearly this does in several different places. 3.4, 8.1, and 8.3. Again, I submit to you that 9.3 is a boilerplate proposition. If it wasn't there, you'd impute it anyway, because that's what partnerships are about. So the only way you can read these together is the way I respectfully submit you must. May I continue?
Sure.
We have two other grounds, Judge. Actually, we have four other grounds, but I only have time to talk to you about two. Section 1002 of the partnership law says that a plaintiff needs to be a partner at the time of the events of which he complains in order to have standing to bring a derivative suit. Mr. Oliver became a partner in 2015. He's complaining about conversion. He's complaining about misappropriation. And as we all know, again, boilerplate, those things happen. A conversion happens when it happens, when a thing is converted, a misappropriation when something's misappropriated. There is clear.
Mr. Poretz,
Yes, sir.
Justice Shulman. But the conversion occurred when she sold the 3 paintings after he was a limited partner, correct?
If that were the case, then
it's not the conversion. There's no claim of conversion when the initial paintings were bought. They could have been legitimately bought. The issue is did she have the right to take the paintings to her home and then sell 3? And his claim is that she unilaterally sold 3 at the expense of the partnership. And that's the conversion.
Well, in the first place, if that were the case, then the other 16 paintings have no business being in the complaint. What Mr. Oliver is complaining about is all of them, and the unambiguous documentary evidence is that a conversion takes place when somebody begins exercising control over something. The documentary evidence of the gallery, most of which Mr. Oliver himself submitted in his order to show cause, says that she began exercising control over these paintings in 1987, 2002. None of them after she. After he became a partner, to the extent that.
So when does she transfer them to her home? When does she take them to her home? And the number of the paintings that she takes to her home?
Those paintings, I think, almost all have been in her home for many, many, many years, and in some cases, many decades. But I didn't argue that because I didn't want to get into a back and forth and create issues of fact as to whether it was 2012 or 1987. That's why we were relying on the unambiguous business records, the ambiguity of which has never been asserted, the clarity of which, the authenticity of which has never been asserted. And again, Mr. Oliver uses those records himself. They establish that Ms. Boone has had these things. She has claimed ownership. She has had title over them since, in some cases, 35 years. In some cases, in every case, before he became a partner, every single last case. So we respectfully submit that 1002 doesn't give him standing, and the carve out for people whose interests devolve doesn't apply because devolve has a very specific meaning. Using it Mr. Oliver's way, writes out of the statute the terms by operation of law. Something devolves automatically, like by inheritance.
There's a question. Is there a question?
I thought there was. I'm sorry.
Okay. Thank you, counsel.
I had one more. May I just say one more sentence?
I'll give you that.
Thank you very much, Your Honor. Third ground, mainly for the same reasons as the second ground, this action's too late. Mr. Oliver filed in 2020, again, for the same reasons I just discussed for you before. All of these works were acquired by Ms. Boone, established by the disputed, unambiguous documentary evidence more than 6 years before, and there's no statute of limitations in this case longer than 6 years. Thank you very much.
Thank you. Counsel, Mr. Galloway, I believe?
Yes. Good afternoon, Your Honors. Brett Galloway for respondents. These are classic derivative claims, and plaintiff did a very good job at defining and distinguishing them. Those are not my words. Those are the words of Justice Masley in affirming, or excuse me, in denying Ms. Boone's and the partnership's motion to dismiss on all grounds. Justice Masley.
Is there a requirement that a limited partner must make a capital contribution?
Not in this limited partnership agreement, Your Honor.
What aspect of this agreement suggests that he does not have to pay the capital contribution?
Section 9.3 and the Fifth Amendment there too. Section 9.
And what does 9.3 do?
9.3. Go on, Your Honor. I'm sorry.
Well, I was going to say, does it allow for a partner to assign rights to another person to be a limited partner?
Absolutely, and I'll read directly from the section that does that. It says in section 9.3, which is page 72 of the record, with the consent of all partners, which we had here, and subject to the rights of first refusal granted in section 9.4, also which we had here, the general partner may assign her partnership interest. Such assignment shall be made as if such assignment were being made by a limited partner. So in this case, you had Mary Boone, the original founding general partner and a limited partner in the LP from 1977, and also the majority partner, assigning her interest to Mr. Oliver pursuant to the Fifth Amendment.
But counsel says that would render this ambiguous, I believe he said, or.
And that alone is the reason to deny their motion to dismiss. If there's a conflict in the terms of the agreement, we need discovery to figure out what exactly the intent or the purpose of the agreement was. So at best, it's very clear to me from a reading of 9.3 in the Fifth Amended Certificate that Mr. Oliver had an appropriate conferral of a 10% interest and has standing to bring derivative claims on behalf of the partnership. If Mr. Poritz wants to continue to argue that section 3.4 and 8.2 control, that's a question of fact that needs to be later on resolved.
What about the statute of limitations? And also his argument that goes with that about the fact that she's had these paintings for years. She's had them in her home for years.
That's not entirely true, Your Honor. The statute of limitations for effectively all the claims in the derivative and individual claims in this case are 6 years. Mr. Oliver obtained his limited partnership interest in 2015 and brought his claim in May of 2020. Within the 6-year statute of limitations. Mr. Poritz would argue and have the court believe that the conversion took place when Miss Boone first acquired these paintings in 1977 or 87 or 2007. It doesn't matter. It doesn't matter when she acquired the paintings. The conversion occurs in multiple instances. It occurs, one, when she sells the 3 paintings for over almost $11 million in 2000.
And what year is that?
2018, Your Honor.
So that's within your 6 years.
Of course, yes. It occurs also when the Boone Gallery is closed by federal investigators and Ms. Boone is indicted and sent to prison for 30 months for tax fraud, for commingling partnership assets with her own, effectively very similar to the claims of Mr. Oliver. And she states, and this language is quoted in the complaint, the gallery is worth nothing. And I'm going to need all the money for when I get out of prison. And then she subsequently closes down the gallery, removes all the art, sends some to storage, sends some to her apartment. But she claims as of that date in 2018, the art's mine. And because she claimed as of that date that the art was hers, when in all preceding instances, my client reasonably believed that the art was a facet of the partnership, of which he was a 10% limited partner, that's the first time where the light bulb goes off and he says, uh-oh, something is amiss here. And Miss Boone is claiming improperly rights to art that simply doesn't belong to her. And I'm happy to go into the partnership law issue of section 1002 if your honors would like.
Any further questions from the bench? Thank you. Thank you, counsel. Mr. Peretz?
Your Honor, first of all, if you look at the defendant's brief, you'll even see that he admits in a topic heading that she, quote unquote, began her campaign of misappropriation before he became a partner in 2015. A misappropriation happens when somebody begins to exercise dominion and control over something. In this case, we're talking about things that were decades in Miss Boone's possession. When she sells what is hers, when she sells what she has exercised dominion and control over, when she sells what the records of the partnership show belong to her, right? Do
they belong to her or to the gallery?
The records of the partnership all say sold to Mary Boone, every one of them, and you've got the page references in our brief. When she sells it, whether it's 2018 or tomorrow, is irrelevant. A conversion is when somebody exercises dominion and control. Finally, last point, to your question, Justice Renwick, about section 9.3, about whether partners can assign their interest. Of course they can, and they can do that in most partnerships, but that doesn't mean that they are freed from the obligation going forward to make a capital contribution. And if you take a look at Article 10th of the certificate, it says that in so many words. The limited partners have not been given the right to substitute an assignee as contributor in his place. That means you don't get the benefit of the contribution Mary Boone made in 1977 simply because she gratuitously assigned you a partnership in 2015. If you want the benefits of a contributing partner, you have to contribute, and no question about it, Mr. Oliver didn't.
Thank you. Thank you for speaking so quickly. Also, you got all your points in.
No, I didn't, but I came close.
Okay, you came close. Thank you both very much.
Thank you, Your Honors.
Next case is John Scott versus Triborough Energy Corp. Mr. Sunshine, is it?
Yes.
Okay, if you just wait one moment. Someone has the mic on. If you just close your mic, if you are anyone other than Mr. Sunshine. Mute your mic, rather. Thank you. Okay, Mr. Sunshine.
Thank you. If it pleases the court, my name is Jeff Sunshine, representing the appellants John and Donna Scott. This is a classic oil spill case. This happens so often under the navigation law at strict liability. On July 31st, 2017, the oil company, defendant herein, delivered oil to the plaintiff's premises.
Counsel, does the navigation law apply to, I guess, preclude your client from any issue of liability if your client is not negligent in this?
Well, it's interesting. To answer your question, the navigation law does discuss that. In fact, that is under the means of storage and means of delivery. The oil tank was the big question for the lower court here. The fact that the oil tank...
I think that's because your client, who is a licensed plumber, put the oil tank in himself without a permit and without going through the right channels of having it inspected, etc., which usually happens after you get the permit and you put it in, and those usual rules you have to follow.
The court actually opined on that and said the permit was not the issue. And in our papers, in the record at pages 633 through 634, it's interesting that the defendants cited the wrong code. They went for Massapequa Park, which is an incorporated village, not where these premises are. And the premises are in Massapequa. They're governed by the town of Oyster Bay. But again, the navigation law does speak to this because this tank was in existence for 18 months. Mr. Scott is licensed. He installed it. It was inspected, not necessarily by the town, but by other people that would inspect the tank. And this tank had no prior issues. But contemporaneously on the day of the spill, when the oil was being delivered, that's when the spill occurred. That's what the navigation law speaks to. That's what the whole intent of this strict liability statute is for. The lower court applied a negligence standard, which is not the standard in this case. It's completely inconsistent.
Is there any question about, go ahead.
Mr. Sunshine, what was the evidence that the plaintiff presented to even establish that the defendant's method of delivery caused the spill? What was the evidence plaintiff submitted?
So in a case like this, the evidence is when the oil company delivers oil and there's a spill contemporaneously, under all of the legions of cases cited, that's enough. They become a discharger of oil. That is what we're looking for here. Under the navigation law section 181, if they become a discharger of oil, they own the spill. They have all of the responsibilities of cleaning up. But it goes further than that. The expert report that we showed indicates that oil had come up and bubbled up by the fill and vent pipe when there was delivery there. The pictures were clear, but even more than that, the expert report of Laurel by Scott Yannick, he was there on October 17th, which was about 2.5 months after the oil spill, and he still tracked and was able to determine that there was still presence of oil there, and that there was oil not only inside the basement, which is clear that the tank had ruptured because of the pressure, but because the oil was spilled outside and was being cleaned up. In the DEC report, in page 338 of the DEC report, they indicate it was human error. In page...
Mr. Sunshine, if I may, the reason why I asked that first question is because I didn't see any evidence, but you bring up the Laurel report where it indicates that the tank was overfilled, but what was the basis for that assessment? Because there was no information in the report regarding how the author came to that conclusion. And I won't ask any more questions for Justice Ringwood. I'm done.
You can ask all the questions you want, as may any other member of this panel. Go ahead, please, sir.
Yes, so once again, this is kind of like a res ipsa issue. When you have a tank and you know that is being filled up with oil and you don't have an oil condition, and then you have a full tank of oil and oil that is now outside where the connection is to the fill pipe and the vent pipe where the oil would then be forced out of, that is clear evidence that there's an overfill within the people in the community that look at these things with the DEC, with experts.
I have a question. Sorry to interrupt you. I have a question. You mentioned before something about the tank rupturing. Was there any question that this could have been a manufacturing defect?
Again, under the navigation law, even if that was the case, that would be for the oil discharger. And in this case, the oil discharger would be the defendant here, and they could go after that. They had access to the site to do their full inspection at the date of the spill. They were there before anyone else, and they were notified of this. They chose to do what many oil companies do, which is what this oil company has done, is they're trying to avoid their responsibility here. It is a clear liability. It's a strict liability, not a negligence standard, and that's what the low
Thank you, counsel. You want to finish your sentence?
Yes, please. So again, it seems that the court here, the lower court, focused on evidence of the oil tank, but that is not the standard. The defendant has built their whole case around that. That is also not the standard. The legion of cases here that talk about the manner of the storage as opposed to the manner of delivery.
Okay, so now I'm going to stop you because I said finish your sentence, but I think you've gone on to the second paragraph there.
Sure.
So you have a rebuttal time. For the respondent? Oh, I see. You are having a... Okay, Mr. Sunshine, would you mute, please? We all mute except for Mr. Pinich. I'm sorry.
Okay, Your Honor, is that better?
Yes.
Okay.
Yes, it is.
I tried to fix my issue before. My apologies. Your Honors, this is not your classic case of an oil spill. You know, the plaintiff wants this court to believe that the appellants themselves are innocent homeowners, but they're not so in this case. They're dischargers under the navigation law, one, for owning the property and controlling the methods of the storage, and two, being the installer of the tank itself. And that is extremely important in this case, Your Honor, because it was not inspected by an independent inspector. You know, it was inspected by the installer with 2 or 3 drivers from other oil delivery companies.
Is that inconsistent with the rules of the town? Or the
typically, Your Honor, I mean,
no, not typically, specifically.
Anytime there is the removal of a underground storage tank or an oil tank, you have to have a permit, and it has to be, the reinstallation has to be inspected. And that wasn't done here. And without any type of inspection, independent inspection, we don't know if it was properly installed, in proper working order. And the fact that it was supposedly, there were no issues in the 18 months prior, this is not an issue where oil tanks are filled on a weekly basis. You know, maybe 3-4 occasions in those 18 months when it was filled. And this could have been a one-off occasion where something with the installation or some other defect was the cause of the spill. And what we're missing here is the causation. Okay, whether it's strict liability or not, the statute, strict liability, does not take away the element of causation that plaintiff needs to establish. And they haven't eliminated their role of any acts or omissions in causing it, or any other potential causes for the spill itself. You know, and with respect to the purported expert reports of Mr. Yannick, you know, he states that there was an oil sheen on the grass near the fill pipe. Well, that could have been from any one of the prior deliveries. It could have been from the delivery on the date in question. We don't know this. The expert
Well, you just told us that we only have deliveries 3 or 4 times, and you think that the oil with this sheen was still on the ground from those prior occasions?
You know what, Honor? We don't know that.
What about the oil in the basement? Or the oil in the, wherever, all of the other places the oil was?
Again, Your Honor, not disputing the fact that there was a spill in the basement. However, we're disputing the causation. What caused that to happen? That's the main issue here.
Yes, no, I understand. I was speaking to your comments that the oil in the grass really weren't due to this occasion. It was due to some other occasion. The oil in the grass wasn't the only place that the oil was found. It was clear that whatever happened that day at that time with that the delivery of the oil from your client's company. Whether it was their fault or plaintiff is also responsible is really the question.
That is correct, Your Honor.
Okay, thank you very much. Mr. Sunshine, you have a minute.
Thank you. First of all, very briefly, I do want to address that the record does not have any evidence about what the standards are relative to permits for the town of Oyster Bay. They do have it for an unrelated incorporated village, Massapequa Park, which is not where the premises is located. Secondly, going back to just what the whole point of the navigation law is that once you identify a discharger, which is what we have here, it's without regard to fault. In other words, the purpose of this is so that the environment is remediated on an expedited basis. And in this particular case, there is evidence that there was never a spill on this property. It would have been reported there. The people were living in the basement where the tank was located. There was, this is an extended family. The oil spill was discovered the date of July 31st, 2017, the date that the defendant oil company connected to the plaintiff's oil fill pipe and pumped oil. That's when this occurred. That is all the causation. And then thereafter, all of the things that occur with an oil spill. There was oil in the basement. There was oil on the ground. There was oil that had to be remediated immediately. There was an extensive oil remediation that had to take place. All of this is it's not tangential. It's all connected. Thank you.
Thank you. Thank you both. Next case is Muller St. Cyr Jr. versus New York City Transit Authority.
Good afternoon, Your Honor. May I proceed?
Just one moment. Okay.
Sure. May it please the court. My name is Michael Marin from Alephtorachus and Panic on behalf of Mr. St. Cyr, the plaintiff appellant. The lower court erred in granting summary judgment by resolving multiple factual disputes and making multiple inferences against my client, who was the non-movement on this summary judgment motion.
Mr. Marin, excuse me, this is Justice Shulman.
Sure.
As I understand it, in reviewing the transcript of what appears to be a bench decision on this round of summary judgment motion practice, Justice Sokoloff was shown two pictures as part of the defendant's defense. I think they were marked as Exhibit B in the record. You know, I don't have the exact page site, but I think you know what I'm talking about.
It's R262, Your Honor.
Good, thank you. And those two pictures were actually, as I understand it, taken shortly after the accident, showing the roadway exactly as it was, not necessarily the position of the vehicles, but exactly the way it was, as one lane of moving traffic with a bus stop on the right-hand side of the picture that I saw from the photographs. You don't really dispute let me do it this way. There was no dispute as to the accuracy of those pictures because, as I understand it on the record, and please correct me, there was no objection to the court seeing those pictures when they were offered by Ms. Hutter, I think, was the attorney of record at the time. Am I correct, sir?
I agree with Your Honor's assessment that no objection was offered.
Fair enough. And those are the same pictures that you used perhaps together with your Google pictures to somehow suggest that the roadway was wide enough for two cars to go side by side and move side by side. Would that be a fair assumption or inference from your argument before the court?
I think that's fair to say, Your Honor.
Okay. And you also don't necessarily disagree that the Google pictures were not exactly the way the street looked at the time the 2009 pictures were taken, correct?
So I would say that they represent the width of Classen Avenue, which I think is the important point here. But I agree that the 2009 Google Maps images shows that two lanes were demarcated with white lines.
Correct.
The 2014 Google images show that the lines were gone. They were removed at some point.
Correct.
But it still shows that it's wide enough for two lanes of moving traffic.
Right.
So I agree that the lines are gone.
Okay. So it's fair to say that based on what we saw, we have parking lines on both sides of the street, one moving lane of traffic, the accessorized van right at the light, and your client pulling in, and again, these are my words, but that's okay, pulling into the right side of the van where there was an open space, obviously, which there's a sign there on the right-hand side on the pole that I had to blow up. I managed to blow up. It said the bus stop sign, correct? Would that be and he was right at the light with the defendant's van. Am I correct?
Well, I dispute your characterization that it was one moving lane, Your Honor. Our entire point is that even though the demarcations weren't there anymore, it still remained a 2-lane road.
It didn't look like a 2-lane road from that photograph, sir.
But,
the two photographs were to me, seemed pretty clear that with the parking lanes on both sides and the angle of the shots, reasonable inferences were drawn that there was one moving lane, that there was no dispute. Your client really was saying, well, yeah, we think both vehicles could move. But the point is that your client was on the right, near the curb, and the van was in the middle when the light changed. And that, as I understand, that was the inferences from the unchallenged photographs that allowed Judge Sokoloff to determine a basis for summary judgment for the defendant, no?
Well, I'd like to dispute a few things you said, if you don't mind, Your Honor. First of all, these pictures were taken at some point, we don't know when, after the accident. They're not pictures of the accident seen at the time of the accident. So in those pictures, there's an orange van and orange cones. There was no testimony that that van or those cones were there, which make the road look narrower. There's substantial evidence that it was a 2-lane road. Ms. Barcliff, who's the defendant driver,
Counsel,
herself, yes, Your
Counsel,
Honor.
you keep on arguing that there was a 2-lane road, and what you are essentially arguing is that this court should ignore the legal road signs applicable to this street. And that is not something that we can do. You have one lane of traffic, of legal traffic, and you have a bus lane, which your client turned right from.
I disagree, Your Honor, because the premise—
You're saying the bus lane is a travel lane?
I'm saying he was never in that bus stop region and that there's enough room for 2 lanes of moving traffic, as was shown in the previous pictures from 2009 and 2014. There's no evidence that the street narrowed between 2014 and 2015.
Counsel, but you see, you are again suggesting that motorists are entitled, who are familiar with a particular street, and the Department of Traffic decides that for whatever reason, safety or otherwise, they are going to change a route. We've had that happen throughout the city, bike lanes and lanes for trees, etc. Okay, motorists are not entitled to ignore new traffic patterns put down by DOT. And your argument is essentially arguing that notwithstanding DOT's decision to change this into a 1-lane street, that because motorists think two cars can fit, they're entitled to do that under the law. That's your argument.
Well, I respectfully disagree with that, Your Honor. My argument is that just because there are not demarcated lines does not transform a street from a 2-lane street into a 1-lane street.
The removal of demarcation doesn't change a 2-lane street into a 1-lane street? That's your argument?
Yes, Your Honor.
DOT makes the decision to remove paint from the street from a 2-lane to a 1-lane, and you're saying motorists can ignore that?
No, Your Honor. I'm saying if you look at VTL 1123, it discusses passing on the right if the road is, quote, of sufficient width for 2 lines of moving traffic. It doesn't say if the road is demarcated for 2 lines of moving traffic. It says if the road is of sufficient width for 2 lines of moving traffic.
You're going to have a lot of people get hit under that definition.
Thank you. You have some rebuttal. For the respondent?
Yes, good afternoon. I want to thank you for stealing my thunder, but let me just add on this. If you look at the points of impact, the defendant's vehicle, right rear passenger side, was struck by the plaintiff's left front side. And if you look further into the evidence, you'll see—
you're arguing that there obviously wasn't enough space for 2 moving vehicles, as counsel suggested.
Absolutely, absolutely. Also, the defendant's right turn signal was on, following the directions of a traffic agent. And when you look at all of the evidence supplementing what you had all said, it appears that at best, the plaintiff was trying to pass on the right-hand side without enough room, misjudging and miscalculating, trying to pass the defendant's vehicle while the defendant's vehicle was in the process of making a right-hand turn. And that just supplements everything that was brought out before. With respect to the vehicle and traffic laws, with respect to the photographs, with respect to the Google map, as you had addressed earlier, it's really irrelevant because the plaintiff was basically trying to pass the defendant illegally and misjudged, and therefore there's no triable issue of fact with respect to how this accident had occurred.
Any questions from the bench? Thank you. I think we're back to you, Mr. Marin.
Thank you, Your Honor. I'll just make 2 points. Opposing counsel brought up the traffic agent, which was in Ms. Barcliffe's testimony. If you look at the two reports that she submitted with her affidavit, both were handwritten by her. Neither of them mention a traffic agent. My client never testified about a traffic agent being there. That's a question of fact that should be resolved by the jury based on credibility. But going back to the other point, our contention is, as Ms. Barcliffe admitted in her testimony, Classen Avenue was wide enough for 2 lanes of traffic. And
not moving, though. She specifically said if they're not moving. In other words, one's parked, perhaps, and only one is moving.
I will read you her testimony. The question. The point, though, is you're saying that 2 vehicles could theoretically move down the one moving lane together, but there would be very little room between them. Answer, yes. She admitted that the road was wide enough.
But there's someplace else where she says not moving. So maybe that's one place, and she perhaps clarified in another place in the record.
Well, Your Honor, as of the non-movement, I think inferences are supposed to be drawn in my favor, not in her favor.
So we should ignore the fact that there was clarification?
I'm not saying ignore the fact that there's clarification. I'm saying if you think that the testimony is unclear, then the inference needs to be.
No, I didn't say unclear. I didn't say it was unclear. I said it was clarified.
Actually, Your Honor, this was the clarification. The testimony started with her saying, well, I'm not really sure. And this was the clarification where she admitted that 2 cars could travel down the lane together.
Okay. Thank you.
Thank you very much.
Both.
Thank you.
James Edstrom and John Brand versus St. Nick's Alliance Corp.
Good afternoon, and may it please the court. My name is Ryan Sesak.
One moment, please. I'm sorry, just one moment. We only have the respondent here, correct?
That's correct.
You may proceed.
Thank you, Your Honor. I have very limited time, so I'm just going to address a few points raised in the reply brief. Essentially, all of
counsel, you represent the defendant.
Yes, St. Nick's in 19.
And I have to ask you, there were mice and rodents infested this place. I think, wasn't the oven replaced because the mice it was infested?
I believe there were many repairs performed.
No, that's not what I asked you, though. I'm talking about the mice and the roaches and the infestation that required the oven to be replaced.
I believe that's correct, that the oven was replaced.
I don't understand how this, at base, is not a violation of the warranty of habitability.
Well, Your Honor, I think as the lower court found that the landlord isn't the guarantor of the property, that extermination services were offered.
Oh, wait a second. Are you telling me that where there's infestation, the landlord is not responsible for clearing that up? Is that what you're telling me?
No,
what is the housing court for in the warranty of habitability? That's not what you're saying, is it?
I'm not saying that. No, I'm saying that the landlord obviously has a responsibility to provide a habitable accommodation.
Good. I'm glad we agree on that.
Sure. And the landlord in this case attempted to do that. Extermination services were provided. They were not often received. They were sometimes.
Well, then he should have gotten another company. Is he only?
They were refused because Edstrom and Brand didn't allow the exterminator to enter. They didn't always answer.
What about the dumpster outside of his window that was commented on repeatedly by different witnesses about being overflowing and not attended to?
Well, Your Honor, I mean, that goes to allegedly why there would have been vermin in the place. I think with respect to
your time is almost up because you only have 2 minutes. So let Justice Kennedy ask a question.
Yeah,
sure.
You talk about the refusal of services, but there was also evidence in the record that plaintiff declined the services because the building exterminator was one of the men who attacked Brand in the lobby. There was evidence of that, correct? So it just wasn't that he just declined services. There was the claim about the building exterminator attacking Brand in the lobby.
There was an allegation to that effect. I don't believe that was ever raised at any point except in response to one occasion. But
the bottom line is that you have a credibility issue. Would you agree there? You mean, my colleague already indicated about the dumpsters. You also had the caseworker who observed a rodent infestation.
I'll conclude this way with respect to habitability. I believe that if the court finds an issue of fact, all that's required here is a damages inquest. Edstrom never withheld rent. It should be sent back, if this is the only issue of fact, just for a damages inquest to determine, again, how much the plaintiffs were damaged.
Thank you. Any questions from the bench? Any other questions? Thank you, sir.
You're welcome. Thank you.
Next case is People versus Gregorio Burgos.
Yes. Good afternoon, Your Honors.
Good afternoon.
May I begin?
Yes, you may.
Okay. Danielle Krumholtz with the Center for Appellate Litigation for Appellant Gregorio Burgos. Mr. Burgos' sentence of 4 years incarceration and 3 years post-release supervision, twice the minimum allowable, is excessive and should be reduced in the interest of justice to 2 years. Mr. Burgos does not contest that his conviction was serious, but 4 years is a long time to spend behind bars, and even a reduction to 2 years would be significant punishment for Mr. Burgos, who played a minor role.
Mr. Burgos is a second felony drug offender, this sentence, this scan of time, the 2 years to the 12 years, takes that into consideration, that he's a second felony offender. Is that correct?
That is correct, Your Honor. But he still received twice the minimum allowable. And this court has long found that generally we should err on the side of imposing the minimum sentence, but instead he received 4 years instead of 2 that was allowed as a second felony offender. Mr. Burgos' personal circumstances in this case warrant a reduction. He is the father of a 7-year-old son with whom he lived with prior to his incarceration and whom he will live with upon release. Research has shown, it was included in the brief, about the negative impact that incarceration of parents has on the children. And this court, the Second Department and Third Departments have all reduced sentences in the interest of justice for defendants with young children at home. Mr. Burgos' employment history also weighs in favor of reducing his sentence. A former taxi driver for several years and supermarket worker, his sentence of twice the minimum is excessive and should be reduced by this court. Second, in looking to the culpability between Mr. Burgos and his co-defendant, there should have been a vast disparity in their sentences. Mr. Burgos' co-defendant, Franklin Guzman, had been under a long-term police investigation for arranging multiple large quantity drug sales. It's clear from the record that the co-defendant was the mastermind behind a large trafficking operation.
Was the co-defendant a first arrest?
I apologize, Your Honor.
Was the co-defendant a first arrest?
No, Your Honor. The co-defendant was also a second felony offender. He had a prior drug offense from 2011.
Okay.
And it was, the record clearly showed in the VDS and the search warrant application that he was being surveilled as part of a long-term gang operation. He was in conversation to sell large quantities of heroin with an undercover officer on multiple occasions, while Mr. Burgos was simply a carrier, simply a bagman, a low level on the totem pole, and therefore has much less culpability in offending in comparison to his co-defendant. The co-defendant was convicted of second-degree criminal sale of a controlled substance, which is an A felony, and was sentenced to 6 years, the minimum for that offense, just 2 years higher than Mr. Burgos' 4-year sentence. This is a fundamental unfairness in light of the co-defendants, in light of his co-defendants, Mr. Guzman's much greater culpability and in his long-term trafficking operation, which is in stark contrast with Mr. Burgos' minor role in a street-level offense.
Thank you, counsel. You have a minute rebuttal.
Thank you.
Ms. Morgan, I believe.
Yes, Your Honor. ADA Molly Morgan for the respondent.
Okay, so Ms. Morgan, let me ask you this. What is the what's the legal range for a second felony drug offender who pled guilty to what Mr. Burgos pled guilty to?
Your Honor, the range is from 2 to 12 years incarceration.
So what about Mr. Burgos suggested that he should get 4 years instead of the minimum to what he pled guilty to? His co-defendant got the minimum to what he pled guilty to. Why was it more appropriate to give Mr. Burgos 4 years rather than the minimum of the range that is appropriate for a second felony offender who pled what he pled to what he pled?
Well, Your Honor, looking to the facts and circumstances of this case, Mr. Burgos had a substantial quantity of drugs on his person. And in addition to that, he had a
But that's what this range allows for. Is that right?
Yeah, yes, that's correct, Your Honor. But the large amount of drugs on his person reflects participation in a large-scale drug operation. And in addition to that, he had a prior conviction for an attempt of the same offense. And that shows.
What was the drug amount in that other case?
Your Honor, I'm not sure that the record is clear how the amount of drugs involved in that offense, and he also pled guilty. So in that case, the record is kind of unclear as to the extent of his involvement.
Who was the? It seems to me that Mr. Burgos was more of the carrier, or the courier, or I can't, the person he's walking behind the other gentleman. He's got the drugs, the other person doesn't. Doesn't it suggest that he was less culpable than the co-defendant?
Not necessarily, Your Honor.
Well, why was he able to plead guilty to something lesser?
Well, he was also charged with criminal possession of a controlled substance in the first degree due to the amount of drugs that he had on his person. It's true that the co-defendant was generally the target of the drug investigation, but due to the fact that defendant Burgos pled guilty, the record is kind of unclear as to the extent of his involvement in this drug operation. And so taking that into account and his criminal history, in addition to that, his sentence, looking at his sentence in context with his co-defendant, his sentence was only 2 years less than that of his co-defendant, but yet he asked the court to go down 2 years to the minimum. So in context, we can see that the disparity is not as large as defendant would have this court believe. And in any event, his claim is barred by the appeal waiver, which he knowingly intelligently.
Is that waiver even good?
Yes, Your Honor. That waiver was knowingly, intelligently, and voluntarily entered into. At the plea hearing, the court made very clear and distinguished between the trial rights automatically forfeited by virtue of his plea and the waiver of his appellate rights, because after the trial court explained all the rights defendant Burgos was.
But the court didn't explain all the rights.
He did explain rights forfeited automatically upon pleading guilty, and then said, in addition to those rights, as a separate and distinct part of your plea agreement, the defendant's plea agreement, he was also giving up the right to appeal. And that was coupled with the written waiver, which also contained that explicit language as to how the waiver of appellate rights was separate and distinct from rights forfeited upon his guilty plea.
Thank you.
Yes.
Thank you. 1 minute, Ms. Krumholtz.
Sure, thank you, Your Honor. Just to respond briefly, first regarding the sentence itself, as my adversary points out, and we're not contesting the facts here. He was caught in the possession of the amount that he did plead guilty to, but the record shows, as Your Honor mentioned, that there were no egregious factors. Mr. Burgos has no history of violence. It's very, very clear from the record that it was the co-defendant who was involved in this whole operation, and Mr. Burgos was just a low-level person who was required to be the carrier of these drugs. And while 2 years, we are asking for a 2-year sentence reduction, but saying at the same time that there's not a huge disparity. 2 years in prison is a big deal for any person, in particular for Mr. Burgos with a son at home. So while
and what about the waiver?
Sure, Your Honor. The waiver was not entered into knowingly and voluntarily. The whole allocution spans about less than half a page between the bottom of pages 6 and 7 in the plea record. Although the court mentions the word separate and distinct part of the agreement, there's no explanation as to really how that is separate from the trial rights forfeited. And more importantly, the court never actually inquires of Mr. Burgos whether he understood the rights that he was giving up with his appeal waiver. He simply asks if his lawyer went over that with him, to which he responds, yes. There's no other inquiry, so there's no way to really know, as is required under Thomas, that Mr. Burgos really understood the rights that he was in fact bargaining to waive up by entering into this plea agreement. So the valid is not waiver, and the waiver is not valid, and his sentence should be reduced.
Thank you. Thank you both.
Thank you.
Crown Jewels Estate Jewelry, doing business as Stephen Russell versus the underwriters at interest at Lloyd's London. Just a moment, please. Okay, you may begin.
Good afternoon, Your Honor. May it please the court, David Benheim, Lipsius Benheim Law for the appellants.
Counsel, you argue that the dishonest entrustment exclusion doesn't encompass an imposter, but there's no imposter exception here. It's almost as if you craft that on. Why doesn't the plain reading that you entrusted jewels to a thief, a fraudster here, why isn't that enough for the DEE to apply? And yes, while you're answering that, doesn't Abrams, the Court of Appeals case, address this issue?
Thank you. So it's not my distinction that the exclusion does not apply to a imposter case. That was the finding in Camera Mart. It was the finding by the Southern District of New York, made that distinction in Barry versus Realty, the North Carolina.
Camera Mart is not controlling here. I think it's a lower court case. Not to mention, I think it was cited by this court, but then that case that cited it was reversed by the Court of Appeals. Mm-hmm. And as instructive as the federal court can sometimes be, it's not controlling here either.
Yeah.
Why don't you tell us why Abrams wouldn't be controlling?
Yeah, and here's the point. The exclusion. The question is, and this is what we argue, is that the Abrams decision, in fact, requires the exclusion to not apply. If we carefully analyze what Abrams stood for, and let's take a look at the exclusion. It says that there's no coverage for the theft, etc., on the part of any person to whom the interest insured may be delivered or entrusted. So now the question is, from whose point of view do you look at this exclusion? Do you look at
Well,
it from
Abrams answers that question, doesn't
exactly,
it?
exactly.
Doesn't Abrams say the controlling element is the design of the owner rather than the motive of the one who obtained the possession? Because plaintiff was deceived and his confidence was abused. He, plaintiff, entrusted his property to a thief.
Thank you. And that is actually exactly our point, is that if we take a look from, if we take a look at from the perspective of Stephen Russell, they entrusted it to Sony and to Jennifer Lopez. That's who they entrusted it to.
No, Jennifer Lopez wasn't anywhere near the place. They entrusted it to Castellana. He was the thief. He falsely cloaked himself with Sony's clout, perhaps, but it was through Castellana and his agents, just like in Abrams. The plaintiff was deceived.
Let's take a step back, okay? Let's take a look at Abrams. In Abrams, a woman walked into the store. Her name was Rose Friedman. She said,
I know her name.
My name is Rose Friedman, and I'm here to get some jewelry. Everyone understood they were dealing with Rose Friedman. They handed over the jewelry to Rose Friedman. She went off to France, never to be seen again.
Counsel, it has more to do. This case has more to do. You have to look to the plaintiff's, the person who's giving up the jewels. You have to look to their mindset.
Right.
The plaintiff here is deceived, and they're deceived because they give the property away thinking it's a good thing, and it's not. So either way, whether you're talking about Ms. Friedman or you're talking about Castellana, they are giving the property to someone who is a thief or related to a thief or whatever it is. It was
no question. But for the exclusion to apply, for the exclusion to apply, the person handing over the jewelry has to be entrusting it to the person they think they're turning it over to. They didn't entrust it to the thief. They entrusted it to Sony. They entrusted it to Jennifer Lopez. It's true, Jennifer Lopez had nothing to do with this, but that's not who, from their point of view, they believed from the person turning over the jewelry, which we just established at the beginning of our argument today, that's whose point of view you need to look at. From their point of view, they were turning it over to Sony. So even though that was not true, that's what Abrams requires to do, is take a look from their point of view. You turned it over to Sony, so therefore you didn't turn it over to the thief. And that's essentially what all of the cases have had, all the courts that had imposter cases come before them have held. So that's the North Carolina case, the Florida case, and the Southern District, Northern Barry, the Camera Mark case. The other, Abrams was not an imposter case. It's as simple as that. Abrams, she came in, she said,
Sir, I'm sorry.
It is an imposter case. I'm sorry, Justice Shulman.
Yes.
Mr. Benheim, but isn't the language in the Camera Mark case, the provision different than the provision here? The provision here in issue, if I got it correctly, says by whomever, wherever, I can be a bit more precise, to whom the interest insured may be delivered or entrusted by whomever for any purpose whatsoever. Whereas the Camera Mark case had provisions that had a series of certain types of people and then a general provision afterwards. It's a very different kind of provision that would suggest a different kind of interpretation. Would you agree to that? Do you agree with that, sir?
No, and I'll tell you, and I'll say why. First of all, that argument that was raised by the appellants, that was by the respondents, I'm sorry, was only raised for the first time on appeal. But putting that aside, the reason why it's not true is because there's the Abrams case had the same language as our case, so it's not, that wasn't the same language had by whomever whatsoever. The Abrams case and other cases where they found that the exclusion does in fact apply, they had the same language as ours. So the distinction between Camera Mark and Abrams is not that language. The distinction is that one was an imposter case and one it was not an imposter case. They were dealing with Rose Friedman, and that's who they were dealing with. So that's how we will address that. And then our second point is that here there is no proof that the messengers themselves were in on the thief. We have no information on the heist. We have no information about the messengers themselves. So number one, the exception.
I just have to go back a minute to Rose Friedman. Yes. And didn't Rose Friedman induce the plaintiff to deliver the 2 articles of jewelry to her for a third person? And that third person, Friedman pretended was a prospective customer. So wasn't it really supposed to be going to the third person, the customer, not Rose Friedman?
They at all times knew that they were dealing with Rose Friedman, who came in, and that's the person that they were dealing with. That's the person that they trusted. That's the person that
But they didn't trust that it was going to be left with her. It was supposed to be going to a customer. It was supposed to be the articles were for a third person whom Friedman pretended was a prospective customer.
Rose Friedman.
That's at 91 and 92 of the decision. And in this case, they were dealing with Castellano. They knew they were dealing with him. That's the person who was sending emails back and forth and who they communicated with.
If Sabatino would have said, "My name is James Sabatino. I'm here to do some business on behalf of Sony," no one would have given over the jewelry. He said Castellanos. Castellanos didn't exist. It was a complete imposter.
It doesn't matter what the name was that he used. You're telling me that you had confidence that it was Sony. In the Friedman case, I guess the plaintiff had confidence that it was to go to a third party. Either way, they trusted the person who was in front of them, Friedman in your case, in the case you cite, and Castellanos in the other case, aka Sabatino. Anyway, any other questions from the bench? Thank you. Mr. Wade, I believe, respondent.
Indeed, Your Honor. May it please the court. My name is Dennis Wade, and I act for the underwriters. I would like to pick up on remarks made by both Your Honor and Justice Schulman regarding Camera Mart and the distinction. I think the court recognizes that Abrams is controlling, but not only Abrams, two recent decisions of this court, Lexington Park Realty versus National Union, as well as Renaissance Art Investors versus AXA Art. But I think the court needs to recognize that this exclusion is like an exclusion on steroids compared to what was in Abrams, because here the exclusion uses the disjunctive or, so it's delivered or entrusted, and the key here is delivery. The goods were delivered, they were handed over to a thief. I think it's of significance that in Justice Ostrager's opening remarks, he said that this was one of the few cases that had ever come before him in which there were no disputed facts. There were degrees of emphasis, but no disputed facts. The plaintiff, the appellant's brief is basically littered with an acknowledgement that these goods were stolen by a thief. In fact, they refer to the fact that Sabatino, the mastermind, so to speak, was convicted for perpetrating the scheme that lured his client into delivering the goods. So I think the controlling precedent in New York, coupled with the fact that this exclusion with the disjunctive delivered or entrusted is like an exclusion on steroids. In other words, it's stronger than even the entrustment, dishonest entrustment wording cited in the earlier cases. So for all of those reasons, I think Justice Ostrager's sound ruling on agreed facts as to which there is no dispute must be affirmed. And unless the bench has any further questions, my remarks are closed.
Any questions? Thank you very much. Okay, Mr. Benheim, we're back to you. Mr. Benheim? Mr. Benheim, you're muted. Do you hear me?
Now I'm not muted. I'm sorry. Thank you.
Yes, okay.
Okay, so I'll just, going back to Abrams and the distinction between Abrams and what happened here. In Abrams, the person who walked into the store, the case is very clear. The Court of Appeal says in Abrams that she had previously established her credit with plaintiff, meaning they knew they were dealing with Rose Friedman, and that's who they agreed to deal with was Rose Friedman. And it's true that in that case, she had given them a story that she was going to then flip the jewelry to somewhere else, but that wasn't a concern of the jewelry company. They were doing a business deal with who they actually had in front of them, which was Rose Friedman. And they had established that it was Rose Friedman from the court in the United States was Barry in Realty, the Southern District of New York also said, look, if they ran a credit check on the individual, they knew who they were dealing with. In our case here, Stephen Russell believed they were dealing with either Castellanos who worked for Sony or Jennifer Lopez. They had no idea that they were dealing with James Sabatino, and that's what he disguised the very essence of who they were actually dealing with, and that is why the exclusion doesn't apply, because Stephen Russell never entrusted it to Castellanos. To James Sabatino, who was the thief. They entrusted it with Sony, Castellanos, all these other individuals who were not. I mean, Castellanos was a non-existent person, so he was not the thief, and neither was Sony, and neither was Jennifer Lopez here.
Thank you.
Thank you.
Thank you both.
Thank you.
Next case is People versus Kevin Richardson.
Yes, good afternoon, Your Honors. Ariel Reed of the Center for Appellate Litigation for Mr. Richardson. Mr. Richardson's 4 to 12-year sentence with the prison component almost double that of his co-defendant is excessive and should be reduced in the interest of justice. Nobody is denying here that the unlicensed cosmetic operation that co-defendant Spence and Mr. Richardson ran was illegal, or that this botched cosmetic procedure resulted in a tragic loss of life. However, if 2 2/3 to 8 years was deemed appropriate for the co-defendant, whom the record suggests was the person who actually provided the fatal injection, a sentence almost double that minimum term was not appropriate for Mr. Richardson and was
Now,
certainly.
This is Justice Kennedy. Now, the co-defendant, am I correct that she did not have a criminal history as opposed to the defendant, correct?
Your Honor, that is correct, but we would.
But I want to add something, and also the defendant did have a prior conviction for tampering with a witness in the 4th degree, as well as attempted robbery in the 2nd degree, right?
Yes, Your Honor, that's correct. I would note that those 2 prior convictions that Your Honor referenced, the most recent, I believe, occurred in 1992, practically 30 years ago. Mr. Richardson has not had any convictions since. He is now in his early 50s. I think the most recent of those convictions occurred when he was in his early 20s, and I would hope that we are not in the business of holding 50-year-olds responsible for their youthful indiscretions when they were late teens, early 20s, because that's certainly not a standard that we apply across the board to everyone, particularly for people who do not look like Mr. Richardson.
Let me ask you this: were they both he and his co-defendant, were they convicted of the same thing? I'm forgetting now.
Yes, Your Honor, they were both convicted of 2nd-degree manslaughter. And
they both had a range of 4 to 12?
No, Your Honor. So Miss Spence was eligible for a 4 to 12-year sentence. She ultimately received 2 2/3 to 8. Mr. Richardson received 4 to 12 years. And there's nothing in the record other than
they pled guilty to the same thing. I'm sorry. Why was her range different?
That's our argument, Your Honor. They pled guilty to the same 2nd-degree manslaughter. One of the arguments that my adversary makes is that it's because Mr. Richardson has a record from 30 years ago and the co-defendant doesn't. However, as I noted, his most recent conviction was 30 years ago. There's no other explanation.
So the minimum sentence here for manslaughter in the 2nd degree is 1 to 3 years.
Yes, Your Honor.
Mr.
Richardson
5 to 15.
Yes. Yes, and I would note that at this point, Mr. Richardson's already served more time in prison than his co-defendant. So what we're really talking about here is the amount of time he's going to have to be on supervision. And this court has recognized the onerous conditions imposed upon parolees and how they can backfire and destabilize reentry. Mr. Richardson has no history of, drug abuse. He's not an addict that needs treatment. He's not someone that's been cycling in and out.
Whose company was this?
Your Honor, it was a co-enterprise between Mr. Richardson and the co-defendant. They were equal partners. They both operated this cosmetic practice. They both, engaged in it over the course of the years. They both accepted responsibility for operating it. There's really no explanation for why, the co-defendant received almost half the amount of time in prison that Mr. Richardson has received. And like I said, at this point, we can't do anything about that. He's already served more time. What we can do, though, is make sure that the amount of time each will have to be on parole is more equitable, considering the circumstances and considering the fact that Mr. Richardson is not someone who needs to be on parole supervision for 8 years, potentially thrown back in jail for violating curfew or traveling to go see a family member. This is not a situation where 8 years of parole, which is what Mr. Richardson would be facing if his sentence stays the same, would be in anyone's interest, his, the state's, anyone's.
Thank you. Let me hear from your opponent. Ms. Lewis?
Good afternoon. On behalf of the people, respondent Jillian Lewis. Your Honors, defendant benefited from his negotiated plea between the years of
Counsel, did the co-defendant plead guilty to the same charge?
Yes.
Was it a joint enterprise?
Yes.
So why did Mr. Richardson get sentenced to a different sentence?
Yes, so the same judge that oversaw the sentence for both the defendant and his co-defendant, Justice Clott, he actually acknowledged that the two factors here were the defendant's prior criminal history as well as defendant's lack of remorse.
30 years earlier, from the criminal history from 30 years earlier?
Well,
Is there something I'm missing?
Well, Your Honor, he was sentenced in 1992 and was in prison until 1993 on a...
So that's 30 years, isn't it?
Well, it was 1993, and then between 2014 is when this enterprise began. So between, I guess, 1993 and 2014, that would be about 21 years.
Okay, so 21 years.
But that coupled with his lack of remorse, and for this, defendant submitted a pro se motion here, actually blaming the hospital that attempted to help Letitia Bynum after she had experienced shortness of breath, felt sick, and her feet turned blue after an injection with the silicone. He actually, in his pro se motion, blamed the hospital for administering life-saving treatment for Miss Bynum's being sick, and as opposed to the injection.
Were there other complaints about him after this was unearthed?
Yes, Your Honor. At the sentencing, there were 3 people that spoke about their trusting both the defendant and the co-defendant having. So
the comments were with regard to both of them?
Yes.
Mm-hmm. And did the co-defendant express remorse?
Yes, Your Honor. The Justice Clott pointed specifically to this in the motions hearing on page 9, saying that, the defendant's sentence here was potentially over lenient.
The defendant's sentence in this instance?
Yes, was potentially over lenient given, his lack of remorse here.
So was his sentence double the other sentence?
So, Your Honor, in terms of sentencing, the co-defendant received 2 2/3 years to 8 years, while he received 4 years to 12 years. And originally, the people offered from 5 years to 15 years, and Justice Clott, however, offered the defendant a plea on those 4 to 12 years. At the
and did the co-defendant join in his papers at all that he said it was the fault of the hospital, or that the hospital?
No, Your Honor, that was an individual pro se motion.
Okay. And at sentencing, you're saying he didn't say anything about the causing this?
Your Honor, he asked Justice Clott if he could plead guilty to just the other charges and wanted to go ahead and try the second-degree manslaughter, and Justice Clott would not let him do that. So in terms of that, he found that that was not him showing remorse and accepting culpability for that death.
Okay, thank you.
Thank you.
Ms. Reed. I'm sorry, where am I?
Oh, yes, Your Honor, I'm here.
Yeah, Ms. Reed, right?
Yes. With respect to the accepting remorse piece, Mr. Richardson pled guilty to manslaughter in the second degree. That is an expression of culpability. Yes, he also—
Pleading guilty is not an expression of culpability, of remorse, not necessarily. It may just mean I'm cutting my losses and I don't want to spend the rest of my life in jail.
And Ms. Reed, I want to follow up because you did say earlier that he did accept responsibility, but I recall that I think he initially insisted that he was not even present at the clinic when the injection occurred, and he was unaware that the injection was scheduled. But then he reversed course and admitted that he was at the clinic and fully aware of the procedure when the prosecutor had confronted him with the cell tower records. That's certainly accepting responsibility.
The cell tower records is an interesting piece of evidence because it actually establishes that Mr. Richardson was not there at the time of the actual injection, which was his claim. According to the decedent, Ms. Bynum, she told the hospital staff that she received her procedure at 7 p.m. The prosecutor's cell site records established that Mr. Richardson's cell phone was bouncing off a tower away from where the procedure occurred. So while he accepted that he was at the facility that day, he vehemently denied that he was there for the actual procedure, and the cell site records bore that out. And so that is the undergirding reason why he wanted to challenge the manslaughter conviction, because the prosecution's own case establishes that he was not the one that injected Ms. Bynum. That was the co-defendant, and it makes no sense that the person who actually provided the fatal injection would get less time than the person who didn't provide it, who all he's saying is, I did not provide the injection, and he's right about that.
Miss Reed, are the defendant and co-defendant of the same race?
I believe so, Your Honor, but the co-defendant's a woman. Mr. Richardson's a man.
Okay.
Any further questions? Thank you. Thank you both.
Thank you.
The next case is Technology Insurance Company versus First Mercury Insurance.
Thank you, Your Honor. May it please the court, Dan Cohane on behalf of the appellant. If the court allows First Mercury, whose named insured was found to be 85% responsible for this accident, and who obviously and clearly violated the provisions of insurance law section 3420 by not notifying its additional insured of the accident.
Counsel, I just have to ask you about the employee exclusion and whether or not at this point, is there any reason that P&R or Terra Nova would isn't everything paid as far as they're concerned? Do they have any other issues anymore?
Does P&R have any money out of its pocket? Is that the question, Your Honor?
Yeah, I guess it is.
No, they don't, Your Honor. They didn't. The money was paid by P&R's general liability carrier, Technology, because the insurance company that had the priority of coverage, who was first in line to pay, refused to take part and sent out a disclaimer letter without following the strictures of insurance law section 3420D2. So it's true, Your Honor, that as is often the case, another carrier stepped into the breach. That was the same situation the Court of Appeals had in Servodone, where the insurance company had denied coverage, walked away, and someone stepped into the breach to take care of the problem. But the issue is the insurance company who had the responsibility, who acknowledges that they screwed up, pardon my colloquialism, they failed to comply with the requirements of the insurance law, they're now walking away. They're saying, well, because technology stepped up and did what it was supposed to do, stepped into the breach, they now can no longer recover back from the insurance company responsible because they paid the claim. This case went to verdict, Your Honor. The case went to verdict. The plaintiff was found 15% responsible, and the First Mercury insured was found 85% responsible. And they're saying we have no responsibility here. Yes, we screwed up. Yes, we didn't comply with the statute, but we don't have to pay a penny because you, technology, stepped into the breach and did what you're supposed to do. Your Honor, I would suggest this: if this court buys that argument and allows that result, then what you're going to have is companies who provide additional insured coverage simply saying, you know what, we're not going to acknowledge coverage. We're going to hope that somebody else picks up the coverage for the contractor or the owner, pays the claim, and then we can walk away laughing with our hands on our wallet. That isn't the purpose of additional insured coverage. And this department, more than any other department in the state, recognizes the importance of additional insured coverage. We have it here. They didn't rely on an exclusion. Maybe they could have. They did not rely on exclusion by sending out a copy of the insurance, the disclaimer letter to their additional insured. The Court of Appeals has made this abundantly clear that they had an obligation to do that. The Sierra case is exactly on point. The Sierra case is exactly on point. An insurance company tenders on behalf of its policyholder, just like technology did here. The insurance company, the additional insured carrier, sent a coverage letter only to the insurance company, just like First Mercury did here. And the Court of Appeals said, not enough. You didn't comply with the statute. You've lost your right to rely upon an exclusion. That's what happened here.
Counsel, this is Justice Kennedy, and 3420 D is not even applicable. There's plenty of case law in this department that it's inapplicable as it relates to a claim for contribution or reimbursement between insureds. So why is this case different?
Sure.
Your case.
Thank you, Your Honor. This is not a claim for contribution. And I know the cases that talk about
or reimbursement.
This claim is exactly like on all fours with the Sierra case. The Sierra case was a case where the carrier for the additional insured stepped up, did what it was supposed to do, and tendered to the additional insured carrier. The additional insured carrier had an obligation under 3420 D2 to send out a coverage letter relying upon an exclusion to the policyholder.
Is technology not seeking contribution from First Mercury?
It's not seeking contribution. This isn't an other insurance case where you're talking about who goes first. This is a claim that technology is prosecuting. Bless you. That technology is prosecuting along with its named insured against the additional insured carrier who had the obligation to provide coverage.
But counsel, so you're seeking reimbursement, right?
Yes. Yes.
Okay, well, same thing. Whether it's contribution, if I could just finish my sentence, thank you. So whether it's contribution, which is not applicable, or reimbursement, 3420 D, that's also inapplicable. So why is it different here?
Your Honor, because we're standing in the shoes of our policyholder. That's the difference. That's exactly the situation in Sierra. You couldn't find two cases more identical than Sierra, where the carrier stepped in on behalf of its named insured and tendered and prosecuted and was entitled to recover. That's precisely what we have here. I know the contribution cases, Your Honor, and I respect you bringing that up indeed, and we discussed that in our brief. Why this isn't one of those cases. This is not a contribution case. This is a case where we're standing in the shoes of our policyholder, seeking to recover what they were entitled to recover. That's the claim.
Thank you, counsel.
Thank you, Your Honor. Is my time expired? I don't mean to.
Yes, it did.
Yeah.
A minute ago, but okay.
Subject
Thank
Your
you,
Honor.
Your Honors. Can you hear me?
Yes.
Can you see me? Because I can't see.
No.
I can't either.
Well, it's okay. We can hear you, so why don't you proceed?
I won't take up your time and thank you.
Take up the time that you've been allotted, 5 minutes.
Okay. Thank you so much, Your Honors. I just want to go straight to the point that, look, all carriers recognize that Sierra kind of changed how we look at 3420 vis-a-vis insurers, both Mr. Cohane's clients, my clients. This tender and First Mercury's response were both before Sierra was decided. So I just want to point that out, that, you know, while there's some salacious language in Mr. Cohane's briefs, that I greatly respect Mr. Cohane about how bad First Mercury was, it was during that time period. And I know Your Honors have seen more than you'd probably like to see of these kind of cases, which come before you because carriers are now kind of like, well, what were we supposed to do and who was obligated to do what? However, this case is not like Sierra. It is not like AVR Powell or Harco or any of the cases that Mr. Cohane cited to that he says are exactly the same for two very important points. One, the insureds prosecuted those cases, not the carrier. And two, those cases, the underlying cases were still ongoing at the time that the courts ruled that the carriers had an obligation to go in there and pick up. To the appellant's argument with respect to subrogation and how that somehow makes something different. That's the first time that this is being argued, was not argued below. But even setting that aside, he just admitted that P&R suffered no loss, not at all. And it's admitted in the record. And so if they're standing in the shoes of the insured and the insured suffered no loss, this is clearly nothing more than a claim for reimbursement. So my point to the court is respectfully that I understand that carriers at that time that Sierra came out may have not really understood where to go, what to do, and that's become pretty clear right now. But how things played out and the timing is very important here, because otherwise Your Honors would be overruling the prior First Department decisions in Bovis Lend-Lease, in Greater New York Mutual, and even the general principle of failure to procure insurance, et cetera, in, and I know I'm gonna say this wrong, in Chattanooga, where an insured, you can laugh at me because I can never say it right, but that an insured who's fully protected by their own insurer, yes, they're entitled to out-of-pocket losses, just like in that kind of situation in Chattanooga, where the Supreme Court said that that was appropriate. But here, P&R was fully protected, even if they were entitled to additional insured status. We do have an employee exclusion that was broad enough to encompass P&R. Yes, the law changed, but technology absolutely got that letter, absolutely applies to them, and they can't use 3420D to their benefit now in what is plainly, clearly nothing more than a reimbursement action.
Now, Ms. Gallagher, this is Justice Kennedy, and it was just technology. That was the only party who made any demand for relief in the complaint, right? P&R did not make any demand for any relief in the complaint, correct?
That's correct, Justice Kennedy. Every cause of action in the complaint is solely pled by technology. Every claim for relief is solely by technology. While obviously P&R is referred to because that is the avenue for coverage, you need to reimburse us for what we paid for, and that's what the complaint says, what we paid for P&R. There is no prayer for relief, and therefore the trial court was absolutely correct.
Thank you. Any further questions? Thank you. We're back to you, Mr. Cohane. You're muted, sir.
I didn't want to interrupt my opponent. I apologize.
Yes, I see.
There are 10 paragraphs in the complaint, which we cite on page 16 and 17 of our appellate brief, that speak about the damages that occurred to P&R. Number two, counsel concedes by saying, well, we didn't know what the rule was until the Court of Appeals came out in Sierra. She concedes that the Sierra rule applies. She just said we didn't understand it. That's not an excuse. Court of Appeals rules in a case, that's authority for precedent. And number three, I forget what number three is, Your Honor, but there was a number three.
Well,
I appreciate the opportunity and thank you for the time.
And we'll find your number three.
I know you will.
Read all the briefs and everything, so don't worry about it.
There was a
And
number three.
thank you both.
Thank you.
Thank you, Your Honor. Sorry about my camera.
It's okay. Tai Wong against 15 Monroe Realty. I think it's Marcia Rakes. Are you there?
Yes, Marcia Rakes is here for the plaintiff appellant. Thank you very much, Your Honors.
Okay.
And
now I just want to tell you that, okay, if you just want to move back from your camera a little, maybe. Otherwise, we can hear you just fine. Go ahead.
Thank you. I respectfully submit that the order raised on appeal is replete with errors of fact and law. And most of all, the court of originating jurisdiction failed to adhere to the proper standard of review for summary judgment motions. It resolved issues of credibility. The defendant testified that.
Well, let me just ask you, is this the case of a stair that is marble and that is extremely slippery, but that there was no debris, I should say, on which there was no debris? I believe your client testified that it was smooth, but there was nothing on it. It was nothing, no debris, no dust, nothing like that. It was just the stair. Is that right?
Well, Your Honor, I must point this court's attention to record 86. The plaintiff testified when he says, what caused you to fall? He said, the smoothest of the step, but he didn't leave it go at that. He said the smoothest of the step and it wasn't flush.
And it's worn. I think he said worn. The smoothness of the step and the worn condition?
Yes, the photograph, which is record 263, shows a tremendous indentation on the nosing of one of the treads where the accident happened. So that's not inherently slippery. That's a defect. That's a
well, I don't know that you demonstrated that, but one thing the case law has indicated, right or wrong, is that a worn marble tread without more is not an actionable defect. And what you have, what your client indicated, was a worn marble tread, because he said it was the smoothness of the step and its worn condition. There was no debris, liquid, or anything else on the step that caused the accident.
Yes, Your Honor, I read the Sims case, and that was quite painful to see that ruling. But yes, and Sims was cited.
A number of cases.
Yes. Now, the point is, the plaintiff didn't testify that the stairs were made of marble. There's no evidence in the record that these were marble steps. In fact, the defendant witness, Mr. Wang, testified the step was made of stone. Now,
okay,
I don't know.
So it's stone, but it's still the smoothness of the step and its worn condition.
Well, I think the inherent slippery classification of a step is limited to steps that are made of materials such as marble that are known to be inherently slippery, plus which...
Sounds like you just told us about another step that's inherently slippery.
Stone?
Whatever you just said. You said, didn't you say, didn't your client say it was the smoothness? Your client himself said it. The smoothness of the step and its worn condition.
I'm sorry, Your Honor. My client's an injured plaintiff. He's not an expert. And where did defendant ever put in an affidavit from an expert that identified the material of the step, that measured a coefficient of friction? Experts do that. That's very common practice. There is no admissible evidentiary proof that the defendants established their entitlement to judgment as a matter of law. And that is another matter in which the court of originating jurisdiction departed from the accepted standard of review of summary judgment motions.
Okay, thank you.
Thank you.
Ms. Golga Singh?
Good afternoon, Lisa Gokul Singh, 415 Monroe Realty. Justice Renwick, you hit the nail right on the head, and of course that makes sense.
I don't know about that. Was this a marble step? And did anybody identify it as a marble step? And isn't it your client's burden?
He identified it as a granite step. Granite, stone, marble, it's all the same. The courts don't say that granite is any different than marble.
This is an interior step, is that right?
They are not the same.
You're right.
Granite and marble are not the same, and I can assure you of that. Just try to buy a slab of each and you'll know by the difference in price. So they're not the same.
I know that you are exactly right. Granite is actually it's a, oh gosh, I forget the word, even though I took it in geology, but it's not naturally formed. It is actually sort of put together. So it's different than marble, which is naturally formed. But as Justice Renwick sat on the presiding case, Reyes versus 83 Post Avenue says that a worn marble step without more is not an actionable defect.
But who said it was marble? Who established that it was marble?
As Justice Renwick said earlier, though, whether it's stone or marble or anything else.
No, but our case law says marble for a reason, because marble is slipperier than other types of surfaces. So if we are going to apply the law that you seek us to apply, which is to marble, then you have to establish that the step the plaintiff fell on is actually marble.
That's accurate, except there are other cases dealing with granite and the inherent slipperiness. It's true that there aren't cases involving steps, but there are cases involving floors. The plaintiff testified here that the condition was still the inherent slipperiness of the stone.
So knowing that it was stone and not marble, did defendant provide anything with regard to the slippery coefficient or anything else?
No, the defendant did not, in part because the plaintiff couldn't identify what portion of the step on which he slipped. He was asked if he knew what portion of the step his foot slipped on, and he said he didn't know. So in terms of taking measurements of the coefficient of friction, there was no way to determine what portion.
Are you saying the steps are made of different material, rung by rung?
No.
Usually steps are made of the same material from the top step to the bottom step. I rarely see a staircase that has wood on some, stone on another, marble on another, right? So either they all are made of the same material or not.
It was absolutely a uniform granite staircase. It had existed for over 100 years. There had never been, according to Mr. Wang, the building owner, there had never been any complaints about it. According to Mr. Wang, the only complaint that he had ever made was that the condition was worn. When he testified at page 86 that he didn't know what the cause of his accident was. And then when he testified that it was worn, he admitted that he couldn't say what portion of his foot landed on what portion of the step to say that it was slippery or that there was some basis by which we could determine where to measure the coefficient of friction. But I would suggest to the court that because this staircase has existed for over 100 years, there had been no other previous accidents on the staircase, there was nothing inherently slippery about this condition. And as the plaintiff admitted also at page 86, he did not slip on any debris or liquid or any other material on the stairs.
Was there, I'm sorry, this is Justice Shulman. The plaintiff's expert, the expert never visited the site and actually inspected the tread and issue because we really don't know that from the expert's point of view, correct?
That's accurate. When you look at page 258 of the record, he testified, or his report indicates that what he reviewed for his opinion was he had a telephone conversation with plaintiff's counsel. He reviewed various documents, which he didn't identify, and he didn't say that he reviewed the plaintiff's deposition transcript. And then he said he also reviewed public records.
And he also raised an issue of lighting, poor lighting, but then again, the plaintiff did not raise any issue of the lighting, correct?
That's accurate. The plaintiff said that the lighting was not a factor, the handrail was not a factor. The plaintiff limited his claim entirely to the worn condition of the stairs.
Thank you. We're back to you, Ms. Rakes.
Thank you very much, Your Honor. I would first like to say that there was a significant misstatement of fact by respondent's counsel. The plaintiff never testified that the step was inherently slippery. He said it was the smoothness of the step that caused him to slip. Smoothness. I don't know if you looked up the word smoothness in the source, if you get inherently slippery, but that's speculative. That's a speculative argument that's not supported by evidence. And also, the point is the court of originating jurisdiction made a determination of credibility. The plaintiff testified that he complained about the steps to the defendant. The defendant testified that no, there were no prior complaints. So, and under the correct standard of review, the evidence is supposed to be viewed in the light most favorable to the non-moving party. The motion court is precluded from making a determination of credibility. And moreover, a lot of evidence was overlooked. Mr. Wang testified that he would sweep the steps twice a week. And since this is a long-standing condition, the worn condition, how did he not have constructive notice? There's evidence of actual and constructive notice. That's enough to raise an issue of fact that was improperly disregarded by the motion court. Thank you, judges.
Thank you. Thank you both. Next case, Trugate Holding versus Nirala Barokian et al.
Yes, good afternoon, Your Honors. May it please the court. Daniel A. Thomas for the appellants. You know, this is a case in which there's a lot of history and a lot of messy history, but
yes,
the appeal is fairly straightforward.
Noticed.
Yeah, and ultimately, this court has had the.
We've waded through it, and my question for you is, why should your client not be stopped from relitigating the timeliness of the foreclosure action?
Well, the main reason, Your Honor, is because the facts relied on by the lower court are just flat out wrong, and they gives a complete pass on required statutory requirements of corporate law. So, for example, the lower decision says there was a default of the motion in 2007, but yet the action was commenced in 2012, and there was never a showing that they were a holder in due course at the time. There was the decision by Justice Friedman that this court upheld in 2016 specifically said, and I'll quote, Yehudai made no showing at trial that he was authorized to bring the action on behalf of Trugate. And that never changed. So showing existed.
True. But then when he went out to Nassau County to dissolve it, I think your client then raised this issue in that instance. Am I right?
Not exactly, Your Honor. In Nassau, there were two dates that are very important. The lower court only focuses on the November 6, 2014 date, which essentially was tantamount to the dissolution court saying, new trial de novo, I am not relying on any prior decisions of Justice Friedman. But the following day, at a pretrial conference, the court succeeded in resolving the case and getting it settled with the proviso that nothing in the court's ruling was going to either, and this is a quote, either create or abrogate the rights of the parties in the New York County mortgage foreclosure action. So unfortunately, there's been sort of a perverting, if you will. That language is the only reason why my client settled, because the Nassau court deferred issues of standing and everything to the New York County court, but the New York County court never pulled the trigger on that. And that's still very much an issue that's alive and well today. So from a corporation standpoint, there are formalities. This corporation never had bylaws. It only had a certificate of incorporation. So BCL 707 requires a quorum in order to transact any business. Mr. Yehudai, acting in the name of Truegate, which is in a direct violation of this court's 2016 decision, did everything in this case, from appointing himself president to commencing this action without the consent of his 50% minority shareholder. And as a result, it's all unauthorized. Everything is unauthorized. And for some reason, the lower court just sort of gave that a pass and didn't really consider it, but it's never been determined by any other court. And unfortunately,
Mr. Thomas, just a question.
Sure.
Now, in the Nassau County action, I thought that the defendants agreed by stipulation. I mean, both parties had agreed by stipulation to dissolve Truegate and to continue the foreclosure proceeding to wind down Truegate's affairs in New York County, right?
Yes, but Your Honor, what's very important is that was pre-answer to the New York County foreclosure proceeding. And the answer that was then interposed had a whole host of affirmative defenses. And the reason, there was no real agreement that there wasn't any consent that they had standing. It was a status quo by the Nassau County Court saying, I'm not going to disturb what's going on in New York County. I'm going to let that play itself out. So with any judge or my adversary to sort of grab onto that as a definitive, as a conclusive ruling that there's been some dispositive findings as to standing is just wrong. And unfortunately, my clients have been dealing with that for a long time now. So the Nassau court was very definitive to say, I am not making dispositive rulings as to any of these. I'm deferring to New York County.
But you were a minute ago, you were saying that the dissolution was improper. But
no, it's not that the dissolution was improper. There was an agreement.
Like that's what
I apologize if I misspoke.
Okay.
No, the dissolution was agreed upon with the understanding that
saying that there wasn't a quorum to transact business, and so we didn't have a right to dissolve it.
No, my apologies. Okay. No right to commence the instant foreclosure action, Your Honor. And they had a special meeting of the board of the shareholders. They didn't have a quorum. They have minutes that say no quorum reached, therefore no business can be transacted. And the notice of special meetings called for business to be commencing this action. So it's like it was ignored. Sorry, Your Honor.
I just want to follow up because, I know Nassau County Supreme Court had noted that, the special shareholder meeting did occur and there was the authorization of the dissolution as well as the authorization to commence the foreclosure proceeding. That was on the agenda.
Well, no, not exactly, Your Honor. There's only two items on the notice of the shareholder meeting. One was to appoint or elect Yehudai as the president, and the other was to commence the foreclosure action. That was the extent, the two items. My client sent a letter saying, I can't make the date you noticed. Can we please give another date? He then ignored it and went ahead and had minutes that said no quorum, therefore no business can be transacted, and went ahead and commenced his action anyway without ever entertaining a new date or contacting my client. And the other thing to keep in mind in terms of the lower court relying on equity, because I do believe the lower court realized there's no case law cited, no statute cited. They realized that we're going to go the equity route. But, you have to do equity to get equity, and you can't create a self-imposed hardship and then claim equity. So there was a complete violation of the actual shareholders agreement that says you can't act alone, as well as the BCL. And so I understand where the court's coming from, the lower court, but at the end of the day, this was a problem of their own creation. They waited a year when they could have done things before, and therefore they're up against the statute. So why is the court helping him out and saying, well, I know you waited to the last minute, so I'm going to help you out here, all to the detriment of my client. And there was also a lot of errors with the preceding things, and I don't need to
Mr. Thomas, I want to just go back because you talk about equity, and I'm glad you brought that up.
Yeah.
Because at the December 12th, 2011 hearing, actually, I know you say that they're unclean hands, but the Supreme Court found that there was no evidence of any fraud.
Well, that's a different thing, Your Honor, because it's all about, there's no evidence of fraud relative to the assignment of the mortgage. We accept that. The unclean hands come with the corporate actions, with the shareholder hat that Mr. Yehudai was wearing in all of the things that led up to this current action. So I'm not in any way trying to find there's an assignment. We accept it, law of the case. but you also have to prove that you are the holder in due course at the time you commenced the action. There was a satisfaction of mortgage filed with the clerk's office.
December 18th, 2012 order authorize Yehudi to commence the foreclosure action on behalf of Truegate? That's how I read that order.
Well, Your Honor, part of the problem with that is that there was not a full understanding by Justice Friedman, who
you
issued
may
that order.
disagree with the judge's order, but that's what the order said.
Well, but there has to be a certain amount of
you take an appeal to that order. You can't move forward and say, you know, I didn't agree with that 2012 order, so I'm going to just ignore that and make arguments that fly in the face of that order. That's what you're doing.
Not exactly, Your Honor. And if I may, at no time did Justice Friedman ever weigh in on whether or not there was the proper grounds that were met. And I wasn't the attorney at the time that she made that decision, but I can tell you this: there is no time, nothing in any of the records.
Keep on making the argument as though the court has some obligation to articulate their position your way. The court was very clear that Yehudi would have a right to commence the foreclosure action against, on behalf of Truegate in the December 18, 2012 order, period.
But this court was clear that he couldn't do so in his individual capacity, and that's exactly what he did.
I said on behalf of Truegate.
But he did so in his individual capacity because he did not have the consent of his fellow shareholder, and that's what the shareholders agreement required. So with this court's reading of the 2016 ruling, combined with the shareholders agreement, I understand what Judge Friedman ruled, but it's incumbent upon Mr. Yehudi to comply with the rules of law and the actual agreement. The four corners of the agreement make very clear he cannot act alone. And that's exactly what he did. So while the judge may have said you have the right to do so, I don't think Judge Friedman forgave all of the corporate governance and formalities in doing so. She basically said you could do it, but you got to do it the right way.
Was there a motion seeking clarification of Judge Friedman's order?
Not by the time I came in, it was too late, but there was for Judge Driscoll's order in Nassau. And
but that's not the order we're talking about.
I understand, Your Honor. But again, to the extent that I don't know that you could really read Judge Friedman's order in a vacuum and ignore this court's prior order and the actual shareholders agreement. So I don't know that she forgave all the corporate formalities that were required to actually institute this case properly, which—
In case you didn't notice, I was on that prior case. So I'm not ignoring anything.
I know you're not ignoring it. I'm just simply saying that, unfortunately, Judge Friedman, on that prior case, she said, Yehudi made no showing at the trial. She said, I don't know about Truegate. I don't know if it's alive, if it's dead. I don't know anything at all. But
thank you,
Yehudi, you
Counsel,
have a right
I've given
to
you, if you just wrap up, I've given you way over.
Thank you, Judge.
Yes. Mr. Feinsilver, is it?
Yes, thank you, Justice Greenwood. In order to understand the case, you have to go back to basics. My client put up $275,000 to purchase an assignment in the name of Truegate. Mr. Barukian put his mother-in-law—
We understand the facts. We understand what happened.
All right, but—
As you can tell from the questions and
the
dialogue so far.
Interesting dichotomy that we simply follow the chronology. The trial of Justice Friedman took place in 2011. In November of 2014, there was no appellate division decision. There was no assertion that Justice Friedman was biased. And Justice Driscoll said, do you want to have a trial? And what my adversary, Mr. Thomas, said is the crux of this case is who put up the $275,000. We say that we did. We believe that we're going to prevail on appeal, so we'll take our chances on appeal. It wasn't until 2016, 2 years later, when the appellate division came down, that all of a sudden Justice Friedman is biased. So in terms of understanding this case, everything my client did was in the context of a dissolution case. there's suggestions there wasn't a deadlock. Of course there was a deadlock. Justice Friedman found that the mother-in-law was the proxy of her son-in-law, Mr. Barukian. She had no independent right to assert. And in her deposition testimony, she had no knowledge of the transaction, didn't think there was a true gate, and she knew she was there to protect her son-in-law. So it's clear from the record she was going to do whatever the son-in-law wanted. As a matter of fact, both Justice Friedman and Justice Driscoll separately found 3 years apart that the real party in interest was Barukian. It wasn't the mother-in-law. And Justice Driscoll noted, for every motion, Mr. Barukian has been here. I've never seen the mother-in-law. After a 5-day bench trial, Judge Friedman said she's his proxy. And there absolutely was a deadlock. They proceeded in the context of a dissolution action. And in terms of everything else is moot when you look at a November 7, 2014 stipulation. They stipulated that the foreclosure would proceed in New York. Not just to dissolution, that stipulation, Your Honors, I'm sure I've read yourself. In other words, she consented. Not only did she consent in the shareholders agreement before there was a default, she consented on November 7, 2014, using the same attorney, Mr. Thomas, who represented Mr. Barukian in the other proceedings, to the case going forward in New York. And that's why we have privity. There are decisions that preceded it. I made a point of showing that there were 2 other decisions by Justice Bluth. On January 5, she determined that there was standing. And they took an appeal from it, but then never perfected the appeal. And that was dismissed by the court. They're now seeking to litigate issues that they already took an appeal from and abandoned those appeals, resulting in their dismissal. If there's any question that any of your honors have, I would gladly.
Thank you.
Same.
Thank you, Mr. Feinsilver. We're back to you, Mr. Thomas. You have 2 minutes.
Thank you, Your Honor. Just briefly, and Judge Mansonet, one thing to keep in mind about Justice Friedman's December 18th decision, my client, Mary Nogray, was not represented by counsel at that conference. She issued that ruling without there being any counsel on her behalf at all. That's just a little footnote I wanted to share with you. And the other thing, I beg to differ with my adversary. The shareholders agreement, the lower court does not, there's confusing consent and notice, okay? You need consent as a corporate entity to move forward. There's no bylaws, so the BCL controls. There was no consent. There's no dispute about that. For the lower court to say, well, no notice was required, well, for what? And then they had a special meeting. He noticed the meeting. The conduct of Mr. Yehudai completely goes against the creative interpretation of the lower court regarding the need for a meeting. And that paragraph 4 of the shareholders agreement is ambiguous at best. It was drafted by Yehudai, so it should be interpreted against him. And there's no way it does no way suggest that you could dispense with the formalities of corporate governance in moving forward. So there's been no standing issues really ever determined by a court. There's never been any consent by Nogray for this, as has been, it's in their complaint, paragraph 21 of their complaint. Do not have consent of Nogray. You can't sue your fellow 50% shareholder either. But so in terms of the money, this is a loan. This is a debt collection case masquerading as a foreclosure action, and equity does not apply to a debt enforcement case. So
thank you.
If you have any other questions, otherwise I rest on my papers.
Very much.
I have an ancillary issue if I could just address.
No. I gave you the time and you said you had nothing further, and I thank you both.
I thought
the answer is no. Thank you very much. Thank you both.
Thank you, Your Honors.
Next case is People of the State of New York versus Jacob Fashikin.
Thank you. Good afternoon, Your Honor. May it please the court. Nicole G. Douglas for the appellant, Mr. Fashikin. In a prosecution for perjury, words matter. In this case, when Mr. Fashikin testified before a grand jury in response to charges that he was acquitted of, the words he used were equivocal, the questions he was asked were imprecise, the meaning of his answers was ambiguous, and as to certain topics, his alleged false statements concerned details immaterial to the grand jury's investigation. As to all 4 counts of perjury, the evidence was legally insufficient and the verdicts of guilt were against the weight of the evidence. Turning to the first 2 felony perjury
His claim to be somewhere where he wasn't at a particular time is immaterial?
No, Your Honor, that we are
which
not.
Statements were immaterial?
Yes, the statements that were the 3rd count of perjury, which concerned his statements as to where precisely he was standing and who he was standing with.
You mean whether he was with his girlfriend or a child? That statement?
Whether he was standing with a woman and child when he was arrested, yes.
Or wasn't the video? Didn't the video show that you're talking about the second day that he went? The day that I won't say the second day. I will say the day that the Zier sisters went back that day.
Yeah, that's correct, Your Honor.
And he was didn't the video capture him walking all over the place without a girlfriend or child in tow?
That is correct, Your Honor, but we are not what I was clarifying about the 3rd count of perjury in the 1st degree is that information, that line of questioning and his answers were not material to the grand jury's investigation. For the 1st degree perjury charge, the prosecution has to prove a false statement intentionally made and that it's concerning a matter material to the grand jury's investigation. With respect to the 3rd count, the insufficient evidence that we identified.
Well, wasn't he suggesting that I didn't have anything to do with selling tickets? I was there with my girlfriend and my son. Wasn't he suggesting the innocence of his presence?
He was giving statements as to his reason for being there. He was not charged with lying about that. He was charged with lying about where he was standing and who he was with. And that information is not material. Moreover, whether he had—
How is that not material? I just don't understand that argument. He is saying his entire defense was that he was there to see a show, that he had a legitimate purpose for being there. And his proof of that was that he was there with his girlfriend or wife and a child. So where he was standing relative to this woman and child is completely relevant to his defense.
It would be relevant to his defense, Your Honor, I would agree, if he was arrested the day that the alleged ticket sale occurred. He was arrested the day after. The reason that he was at Madison Square Garden the day after the alleged incident occurred, a heavily trafficked, popular area, is not material to whether he was the person present at Madison Square Garden the day before selling fake tickets, conduct that he was acquitted of.
But the day in question when you're not talking about the fact that the Zier sisters pointed him out and said that he was the person.
No, and he never disputed that. He did not testify that he wasn't the person who was identified by the Zier sisters in terms of immediately prior to the arrest. Obviously, he disputed being the person that sold the tickets, but he acknowledged that when he was arrested, he was at Madison Square Garden. He was standing near the cancellation line, and there was no dispute that he was the person arrested immediately after the Zier sisters identified him and reported it to the police.
But what about the walking around and the video? I don't know if you addressed that. That same day, he was also spotted walking around in the video. Why doesn't that go to the consistency of the day before and the sale of the tickets? I think he was even speaking with people, walking around and speaking with people the second day.
Yes, the video does show that, and it's not, we're not saying that the evidence was legally insufficient to show that the statement was inaccurate or the falsity of the statement, which is a separate element, but it's whether it's material to what the grand jury was investigating. And the grand jury was investigating whether the day prior he was present at Madison Square Garden selling fake tickets to the complaining witnesses.
I'm sorry, this is Judge Schulman. But wasn't he also convicted of third-degree perjury? Which means that, just bear with me, give me a second to get it out and then I'll. So the third, as I understand that, that's a crime of swearing falsely. So if he's asked to describe what he was doing on the 19th versus the 18th, where he says, okay, I was there to buy tickets for my girlfriend and child for a Bieber concert, but I wasn't going to stay there. I was just there to do that, and then eventually got arrested and all that. And then the surveillance video contradicts. It's proof contrary to this false statement he made about why he was there the next day. That is a crime, and then the evidence does support that for a conviction on third-degree perjury. You agree or disagree with that?
That would be accurate, yes.
That was one of the convictions. That's where he was convicted for that as well. Your whole argument questioned the first degree. In other words, perjury in the first degree, which requires sworn statements that are material to a particular action. Am I correct?
Yes, though his conviction for third-degree perjury, while Your Honor is correct that he was convicted of a count of third-degree perjury, that third-degree perjury count had nothing to do with the circumstances of his arrest. That third-degree perjury
had to do with the Lehman College.
That's correct, Your Honor. Yes.
Counsel, can you address the excessive sentence argument? I know that he was sentenced to 5 years of probation. He's currently on probation. Can you address that?
Yes, Your Honor. Mr. Fashikin had no criminal history. The prosecution highlighted throughout their presentation seeking an extensive term of prison, 1 to 3 years, the fact that he had been arrested before and also presented as if he had engaged in the behavior that he was acquitted of. But for someone like Mr. Fashikin, he was a young man. He had no criminal history. There was no evidence that a maximum term of probation was needed. He had strong community contacts, lived with his family, had a degree, and also had plenty of support from different volunteer organizations that he had been involved with long prior to the offense.
Excuse me, this is Judge Schulman again. I'm sorry to interrupt. He was convicted in 2017?
Yes, Your Honor.
Okay. And I assume he did his 6 months right away?
That is my understanding. He is on
and
probation.
I assume within, if it's December 2017 going into 2018, so the probation period started, so that we're only talking about another year now. Am I right? I mean, my math may be off a little bit, but I mean, at this point, is it moved? Is it over? I mean.
Well, he is still subject to the terms of probation right now. And
how much probation time is left? How much probation time is left?
I don't know the exact amount. I believe it's at most another year of probation remaining.
And you're asking for a reduction to what?
Well, we are asking for a reduction to ideally to at least the 3 years, the minimum amount, or it is also possible that a conditional discharge could be entered in lieu of the split sentence that was imposed, particularly given that the offense that he was in the grand jury for and arrested for, he was ultimately acquitted of. He now has these felony convictions on his record for conduct that he was found, for circumstances that led to his arrest, that he was found not guilty of
He's
engaging.
acquitted. So he's acquitted of the ticket sales and convicted of the perjury.
That is correct. Yes, that was the outcome of the trial, Your
Let me just ask you one other question. When he was arrested, when he was on release prior to his conviction, did he commit another crime that was dismissed on 3030? Or was he accused, I should say, of committing another offense, which was dismissed on 3030 grounds?
My understanding is that the 3030 dismissal predated the incident in question here. He was, and as is disclosed by the people at sentencing, he was arrested at Madison Square Garden, apparently, between the verdict and sentencing. But my understanding, though obviously it's not in the record, is that nothing came of those charges. He does not have any other conviction on his record aside from this case. So whether, but I, in full disclosure, don't know the reason
I understand
where that case went.
Thank you. Let's hear from opposing counsel. Mr.
May it
Morales.
please the court, Luis Morales for the people. Not quite sure where to start because we went a lot of different places here, but I'll begin with the materiality count just to discuss that a little bit. And I think it really goes to the jury charge with respect to what's material isn't necessarily criminal conduct, but it's any testimony regarding that is going to support or give credit to the witness with respect to a main fact at issue. The fact at issue here being this alibi misidentification defense. You know, he recognizes that being present at the same location and time as on the following day, it needs some sort of explanation and provides a false one that is flatly contradicted by the surveillance footage and the eyewitness testimony. And just to the extent there was some clarity with respect to Justice Schulman's question, you know, if it was to be found that that count is immaterial, Ortiz explains that it would be reduced to third, not dismissed altogether, although that my contention is that there was ample materiality with respect to that count. With respect to the first two counts, I think, it was very clear that he's saying in two separate statements, one that's brought out in cross at 7 p.m., at about 7 p.m., I'm in Brooklyn, I'm in Cleason's gym. The falsity of that's borne out from the testimony and the cell phone records. The second charged count was that very common grand jury practice of the prosecutor saying at this time and place and date, where there's an investigation regarding this time and place and date, and he says he was not there, and quote, at the time and place of where I'm being accused, I was not there. I don't think there's anything equivocal about those statements. Would the panel like me to address any
What about the sentencing issue?
Right, I would
This is his
acknowledge.
first arrest. He's acquitted of the charge, and he's in his 20s, late 20s. They say male's mind doesn't fully form until 25 or whatever it is. He's 28, not much more. So maybe it took a little more for him, but this is just totally stupid, complete stupidity to lie on these issues, assuming that he lied. What's the point of 5 years probation? He did go to Lehman. I don't know if he graduated with honors, but he went to Lehman. There's no dispute as to any of those facts. He's got a very supportive family. You know, he did dopey things. Why does this young man need to be on, he's already got the conviction. It's a first arrest. I don't know why he didn't plead guilty. I can't explain that to a misdemeanor. Maybe you all didn't offer that. Was that offered? Plea to a misdemeanor?
Your Honor, I don't have that in front.
I didn't think.
I'm not sure if that's in the
Okay.
record. But
all right, but my point is, he has a felony on this charge, and he's got to have 5 years probation. The conviction itself wasn't a sufficient punishment here.
yeah, I mean, Your Honor, and my adversary mentioned it as well. First of all, our proposal was rejected out of hand by the judge of an incarceratory sentence, and taking into consideration those factors that you're mentioning, that did have to be balanced against the fact that not only I'll speak to the act itself, but going back to Madison Square Garden and getting rearrested between verdict and sentencing showed a pretty blatant disregard for the proceedings themselves, which sort of reflects what he did himself in going
So
into the
3 years of probation wouldn't have been sufficient? Isn't that the minimum here for a first arrest?
Isn't that the minimum? Well, I mean, no, in fact, the minimum is it could be an adjournment.
It could be nothing.
Dismissal.
Could be
That's
nothing. You're
correct,
right.
yeah.
Thank you for reminding me. So why wouldn't 2 years have been enough here for a first arrest of somebody who went to college? Nobody challenged that he didn't graduate with honors, has a supportive family. Why is this necessary? He has the conviction. His family has been there every single time he was in court. It says nobody challenged it. This is, I understand, but 2 years wasn't enough.
And I think the judge had to take that all. Justice Bartley was thinking all about all of that and weighing all of that and thinking about, and maybe if he hadn't shown back up at Madison Square Garden right before sentencing and got arrested for Jingle Bell tickets, that's a different equation. It just with that added to the grand jury is a process.
I just look at some of the cases where people are getting, I understand they have more time in jail, but the same 5 years for drugs, or the same 5 years for a gun, or the same, I mean, is there no balance that this guy goes to college? He's at least got that sensibility. He's got the supportive family. He's selling tickets. It's a nuisance. I mean, it's not good. It's a crime, right? He's convicted, but he's got to have 5 years, just like the drug dealers and the drug addicts and the gun possessors and everybody else. Isn't there a difference in what his background than those? I'm just curious of the thing.
No, and I think the balance is in those drug cases and gun cases, there is this incarceratory sentence. Here he received what the equivalent of time served by the time the verdict was announced.
Well, it wasn't time served because he was in there for 6 months.
I'm not discounting.
I mean, I understand, but he was in there for 6 months.
Right, but he wasn't in there for the 2 or the 4 or the 3.5, some of those minimums for the B and C, or even the term that he could have had imposed, which...
No, because the term that he was incarcerated presumably was supposed to have the same effect that the other incarceratory periods that are longer have for those people. My question is, why is the probation the same?
I mean, I think it goes to the specific acts that he's doing in this case, and most significantly, his repeating that act while the case was still pending shows that supervision perhaps shouldn't be hanging out at Madison Square Garden, or should be checking in with someone along the way.
Okay.
Thank you.
Ms.
Geoglis.
Geoglis? What is it?
Geoglis.
Geoglis.
Thanks.
Yes.
I would just like to spend the few moments I have focusing on something that respondent pointed to, which were the first 2 charges of first-degree perjury, and counsel presented it as Mr. Fashkin having made very unequivocal statements, and looking closely at the actual words that Mr. Fashkin spoke during his grand jury testimony, he clearly made clear to the grand jurors that he was estimating as to his movements and whereabouts on the date of the alleged fake ticket sale. And, counsel pointed out that he went into the grand jury and said, here's the date and time of the alleged incident. I wasn't at Madison Square Garden. That was not proven to be false. That was his position, and he was found to have not been the person who sold fake tickets to the complaining witnesses in this case. He was acquitted of that conduct. And so I would just note that the equivocation in his testimony before the grand jury makes it so that the evidence is not sufficient for the first 2 counts of first-degree perjury as well.
Thank you. Thank you both. 320 West 115th Realty versus All Building Construction.
Yes, good afternoon, Your Honor. Tom Mulaney for the appellant.
Good afternoon. You may begin.
Okay, thank you. From the trial court's decision, Your Honor, there was one thing that leapt out at me that was not not treated correctly, which was that there were two contracts that were entered into. They're so-called Contract A and Contract B. And the trial court opinion found that all of the alleged misrepresentations came after apparently both contracts. And that is not correct. There is a claim in the pleading, in the amended complaint, that the request for Contract B, which came before Contract B, came in May 2015, was in fact a fraudulent act because it also pled a price term, promises to finish by certain dates, etc., as well as being a breach of the implied covenant. But that came before Contract B, and so the fraud claim should not have been dismissed against either Mr. Campanella or ABCC for that reason alone. And that is the pleading that the Contract B was a product of fraud is at R52 and 53, and the trial court opinion that the misrepresentations were all after Contract B is at R42. I would also note that Mr. Campanella can be found liable for committing fraud on the corporation's behalf. It was properly pled. It was properly pled that he diverted funds from the trust account for his own personal use, and that is pled at R50. And there's not necessarily a claim of alter ego or vicarious liability that needs to be pled that can stand alone. I would note,
Counsel, I just want to go back.
Yes.
You know, with respect to the fraud claim, you know, what breach of duty did you set forth that was even separate from the breach of contract? Can you point me to, the allegations where you set forth a breach of duty that's separate from the breach of contract?
Yes, and I will anticipate where Your Honor is headed, which is that when there is a statement of a present fact, and that statement is false, that is held to be, probably just by some of the courts in this state, not by all of them, that is held to be a breach of a separate duty. And that's the Channel Master line of cases, of course. That is the separate duty that is breached here. There's a candid admission that the contract meant nothing, that the price term meant nothing. That was not the price term. And it is pled that if that had been correctly told to appellant, it would have gone elsewhere. Now, it is true that when you make a statement of present fact that you know is false at the time you make it, you are also making a misstatement of future intention. But that can't mean that because it is also a statement of future intention, it can't be a breach of a duty, because then there'd be no way to have the fraud and the breach of contract claims coexisting. And it is a law that can coexist. And I would put it to Your Honors that what other kind of case could there be than when the principal of the company, and obviously the one who is directing its conduct, has signed two contracts with stipulated sums and says, that didn't mean anything to me at all. That was never the number. It was never the price. You may have relied on it, but I knew when I was signing it that it was a lie.
I'm glad you brought that up, because
Yes.
What about the fact that, the agreements provided that the parties, indicated that the prices were estimates that was subject to change. Can you address that?
Yes, I can. If that is so, then there is no price term that's agreed to, or it's maybe ambiguous, but there's no price term that's agreed to. That's an agreement to agree. That's a fraudulent statement that would be outside of the contract because it was not a term that was finalized. It almost certainly requires some additional discovery to determine what the parties thought. The court found only that the estimate was not an enforceable contract term. That was not a position that any of the parties had made below. But if that's true, that raises other issues that have not been addressed in the appeals, but would preclude a dismissal at this stage.
Thank you. Let's hear from Ms. Erickson.
Good afternoon, Your Honors. May it please the court. With respect to the claim for fraudulent inducement where the appellant has been discussing, as the lower court noted, the claim is entirely duplicative of the breach of contract claim. The allegations alleged against ABCC are for essentially failing to perform under the contract and abide by the alleged contract price, or not the alleged contract price, excuse me, the stipulated sum in the contract. The contract is clear that there are provisions which could add or deduct from the contract price, and this is normal throughout the construction industry. There's change orders and things along those lines that are completely common, occur on a daily basis on all of these large construction projects throughout the city. And that's essentially what the contract price is in this contract. With respect to the claim of fraudulent inducement, again, all of the statements attributed to Mr. Campanella and the actions attributed to the company itself are things that occurred after the initial contract was agreed upon. So for Mr. Campanella to say 2 years after the contract was signed, he didn't think this is the contract price, and then to say, well, that was his intent 2 years earlier is, is very far-fetched, and it's asking for something said in the heat of the moment by Mr. Campanella to show what his intent was 2 years earlier. Furthermore, unfortunately, Mr. Campanella is deceased, so we were unable to get his rebuttal to that at this point. But in any event, the claims against him personally just should not stand as well because he's a member of the corporation. His actions are on behalf of the company, and there's nothing that has been alleged that should impose personal liability against Mr. Campanella or now his estate. So those claims were properly dismissed by the lower court as well, by Justice Scarpula. And I know the other two claims weren't addressed in counsel's opening statement. However, both of those claims were, the claim for negligence was also properly dismissed as detailed at length in my brief, and as well known by this court, there is no negligent breach of contract. There's no independent duty on the contractor in this case to the owner, which would allow for a negligence claim. As for the last claim, the claim of covenant of good faith and fair dealing, the lower court was correct again in saying that this is, again, duplicative of the claim for breach of contract. And if you notice, there was a reason why the breach of contract claim was not included, because, if that claim proceeds, discovery can go on that case, but all of these others are duplicative and will just result in duplicative damages, et cetera, that are just improper.
Thank you. We're back to you, counsel.
Yes, Your Honor, thank you. All contracts allow for changes to the contract if all the parties agree to it and modify it in a writing. What is alleged by us is that the requests for change orders, the process by which the price could be properly adjusted upward, was not followed also. There is no evidence whatsoever in the record that there were properly followed procedures to adjust the price. And so that does not do anything to save the opinion, frankly, and the respondent's argument. The fact that it can change means nothing. They can all prices can be changed. Two, it is not correct that the implied breach of covenant, good faith, and fair dealing claims are entirely duplicative of the breach of contract claims. But the court said, the trial court said below, explicitly on the record, was that necessary corollaries of explicit contract terms get swept into, the exact words, the contract claims. That is not correct. If it is not an express term, it's an implicit term. And if it's a necessary corollary, it's one that is necessary to bring about the fruits of the bargain that the parties enter into. That is the definition of the implied covenant of good faith and fair dealing. So when it's alleged that bad faith requests for change orders, requests for additional monies, refusal to show up on time, refusal to give keys, etc., when those things are done, when we're going to do change order contracting, and the vulgar phrase is used to describe that, those things are the breach of the implied covenant of good faith and fair dealing. It was adequately alleged. It's very similar to the Bank of America versus Solo case, and it does change the quantum of damages.
Thank you. Thank you both.
Thank you, Your Honor.
Robotham versus Wachenfeld. Hope I got that right. Hope I pronounced that well.
Yes. May I begin?
Yes.
Good afternoon.
Good afternoon. You've been waiting a long time.
Thank you. And may it please the court, Your Honors, my name is Stephen Beispel. I represent the law offices of Stephen Beispel, and I represent the appellant Jim Robotham. This is a defamation case. Mr. Robotham was libeled on a Facebook post by the respondent defendant Jeffrey Wachenfeld. Can you hear me?
I can hear. Can you hear me? I'm
Yes,
getting some. Okay, good.
Okay. Excuse me. There was a post, a Facebook post on the Facebook.
So we know the post. It was that he was a crook and
Jim is a crook. Worst company
bad
to do
business and something like that.
Yes.
Right. Okay.
Yes.
So let me just ask you, because you know statements are not actionable if they're opinion or hyperbolic. Is this statement one of those? You're a crook, and your business stinks, or whatever he said.
Yeah, I think the key factor here, and I think this is what the motion court missed, is the context, the entirety of the post. First of all, it was not on the post.
You're saying it's mixed opinion?
No, well, let me, what I'm getting at is that because it was placed on the Facebook page of a business that Mr. Robotham worked with. He did work for them. He was not an employee, but he did a lot of work for them. And, so it was not just general. Those people, the members of that company of 15 Degrees, who really were the intended audience of that post, could reasonably believe that it was true or truthful or could be true.
On what basis? That the person who they knew was a crook? For some True Value person put that down? Having done business with?
Well, first of all, it's suspicious. Why would someone go out of their way to otherwise libel an
I thought you were going to say that perhaps somebody going to attempt to do business with 15, whatever the company was called.
So that's true as well. Let me, 15 Degrees.
With 15 Degrees,
it's an advertising.
Think, I don't know if I'll do business with them. There's some guy
with them
there
or with him.
That might be.
Or with him as well. I was going to get to that.
But what was the basis of, I'm just asking, what's the basis of that? There's nothing to test the validity or the truth of that statement. It's one of these, you just don't know from the statement. It seems like nonsense.
No, I don't think it's nonsense. To quote, I don't think it's nonsense. Maybe it's regular sense. Yeah.
Maybe it's opinion.
Well, it's here's the kind of philosophical problem with all of these cases, in that it's got to be fact, but it has to be a false fact. So what are false facts if not combination of fact and opinion? But it really goes to the receiver, the receptor, the potential audience. That also gets to the area of and concerning. Obviously, it didn't say Jim Robotham's a crook. It only said Jim, and that is not specific potentially, but it was specific enough to the people at 15 Degrees, enough for them to cut off to really freeze him out. and it injured him financially and in terms of his reputation, and it cost him a lot of business. So he was injured by that. I think there are cases. I cited Atanasio, where the word crook was used. I think it's a very similar. It's very analogous. It was a contractor, Mr. Rossi versus Atanasio. The Rossis were contractors, building contractors. Atanasio was a customer of them. Somebody who they did, yes, the Rossis were, the Atanasios were customers. When Mr. Rossi was meeting another potential customer, the Atanasio said basically, he's a crook and a shyster, don't do business with them. And the third department thought that was actionable. I think part of it is because of the whole context of it. Not just the words by themselves, but where it was said. It was said in front of a potential client. And in our case here, it was also said in front of, it was directed right to Mr. Rowbottom's.
Well, in that other case, the Rossi case, there seems to be a lot more background with the parties in that case, so that there was some ability to talk about the truth of it, or, prove it true or false. That's the thing that's missing, maybe missing here. The Rossis, there's this larger verbal assault about what was going on, behind the scenes that all the parties were involved in. But let me hear from your opponent, and then I'll come back to you.
Thank you.
Mr. Clinton.
Thank you. Thank you, Your Honors, and may it please the court to just respond to the mention of Rossi versus Atanasio, where it picks up. In that specific case, even though it's third department and not specifically binding, there it shows that the record demonstrated that Miss Atanasio specifically believed that the plaintiff, the seller of the house to her, had lied to her. Clearly, in this case, Mr. Wachenfeld did not have the belief that, Rowbotham was a crook, because less than a month after he found out about the posting, he went and took it down and sent an apology email to Mr. Richard Clark at 15 Degrees that said, I found out about this posting, I took it down, and I replaced it with a 5-star rating that said, I don't believe the content that was placed there, and I would love to do business with this person. I
think he was encouraged to do that, wasn't he? By Mr. Rowbotham himself?
Well, sure. Mr. Rowbotham did send him a note about the two alleged defamatory tweets, yes, but whether or not he was encouraged to do so, he did in fact go ahead and take that posting down. And also, obviously, it's been established in the record, or at least attested to by Mr. Wachenfeld, that he himself did not make that posting. But I want to get back to a point that my adversary said, when he said context matters. I couldn't agree with him more, except I think that the context that we're talking about two different types of contexts. As this court has noted multiple times, specifically in Sandals Resorts versus Google, the specific context of the internet itself leads certain statements such as this to be given less credence and to be analyzed differently than other such similar statements that are made in traditional print media, or et cetera. There have also been numerous cases, which we cite to in our brief, and I won't belabor those points, that make similar statements, such as Cardali, wherein an attorney says to fellow attorneys at his firm that his soon-to-be former boss was a criminal, and that statement was held to be non-actionable opinion because that statement was not being able to get a specific definition. So should be the case with the word crook, as it's being used herein. Does the panel have any questions?
Oh, I thought you were going.
No.
Thank you very much. We're back to you, Mr. Biespel.
Yes, that's fine. Biespel. Your Honors.
Okay.
That's okay. Your Honors. First, let's get back to the procedure here. This was my client's motion for summary judgment, which not only was denied, but then the court searched the record and granted summary judgment for both defendants. There's an additional defendant, which is the hardware store itself. They chose not to appear today. So what we are really asking, Your Honor, what my client is asking, that decision be overturned. You and I have been parrying on, there's facts. There are definitely facts in dispute here that should be properly decided by a jury. And we ask respectfully that this motion for the defendant's summary judgment be reversed, and that this case be returned to the calendar, and then it could be determined. Maybe we have to go to trial, or this can be resolved in another manner. But I think summary judgment against the plaintiff appellant was an overreach in this circumstance, and this court can help my client who was injured. There's questions of damage and injuries and financial loss. He has gotten a scarlet letter attached to him. That letter is C for crook, and we want to remove that and clear it up. Thank you.
Thank you both.
Thank you, judges.
Yours was the last case. This concludes argument for the appellate division today. Thank you very much.
Thank you.
Court is adjourned.
Thank you.